And we're live. So good morning, everybody. This is the meeting of the Joint Standing Committee on the Judiciary. We will start today with 6 work sessions. For those of you both on the panel and in the attendee space, I understand there's been a little bit of confusion over the order of bills. The bills are listed on our website in numeric order, but we take them up typically in the order indicated on the published notice of the work sessions, and that can be found kind of toward the bottom of our page. I did also post in the chat for all attendees and panelists the order that will take up bills today, and there has been one slight change. We'll start with 1160, and then we'll do 737. Put on my reading glasses. 461, 785, 681, and then 478. And again, that information is posted in the chat so that everybody has access to the order. And so before we launch into our work sessions, we'll start with our usual round of committee introductions. And this morning, let's start with Representative Babbage.
Hey. Good morning, Madam Chair and everyone that may be listening. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Thank you, and thank you for that brilliant smile. That's a great way to start our meeting today. Representative Moriarty.
Thank you, Madam Chair. I'm Steve Moriarty. I live in Cumberland. My district, number 45, consists of Cumberland and part of Gray.
Thank you. Representative Sheehan.
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I'm proud to represent the good people of Biddeford's House District 12.
Thank you. Representative Libby.
Madam Chair, good morning all. My name is Laurel Libby, and I represent District 64, which is part of Auburn and all of Minot.
Thank you. Representative Poirier.
Thank you, Madam Chair. I am Jennifer Poirier. I represent Skowhegan and part of Madison, which is House District 107. And I apologize, but I do have some other commitments today, so I'll be in and out a little bit.
Thank you. Representative Thorne.
Thank you, Madam Chair. Good morning, everyone. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a little portion of Etna, coming to you today from fabulous Penobscot County.
Thank you, Representative Thorne. And Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin. And my connectivity may be a little off and on today, so I'll probably be off video most of the day, but be participating as much as possible, as well as I have 2 bills to hear in other committees. So nice to be with you all.
Thank you. My co-chair, Representative Harnett.
Thank you, Madam Chair, and welcome everyone, both in the attendee room and watching on YouTube, and my colleagues on the committee. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside.
Thank you very much, Representative Harnett. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. I will start out chairing this morning's work sessions, but I will also be called to another committee at some point and will miss some of today's work. So I just want to go over the work session procedure that we follow. So the work session is really the committee's time to debate and vote on the legislation that we've previously held public hearings on. And so you'll notice that most of the discussion today occurs with our analyst and among committee members. We do occasionally invite, well, we always invite the bill sponsor if the bill sponsor is present to be on the panel with us. And then we sometimes may ask people who are on the attendee part of the meeting to join us in order to address specific committee questions as we debate and decide how we're going to vote on bills. And I have been remiss in introducing our committee analyst, Peggy Reinsch, and also our committee clerk, Susan Panett. And good morning to you both.
Thank you.
And with that, we will open the work session on LD 1160. That is an act to reduce the burden on courts and promote the resolution of civil cases.
Great. Okay,
Oh,
thank you. Oh,
Peggy, I'm sorry. Representative Newell, my apologies. I did not call on you. Please introduce yourself.
Thank you, Madam Chair. I am Rena Newell. I am the Passamaquoddy Tribal Representative, and I live here in the beautiful Down East. Thank you.
Thank you so much. Okay, so we'll open our work session now on LD 1160. And Peggy, could you please give us your analysis on the bill?
sure. Just real quick, because there is an amendment that has been prepared. So LD 1160 is an act to reduce the burden on courts and promote the resolution of civil cases. Section 1 amends the pre-judgment interest in a civil case, and Section 2 amends the post-judgment interest in a civil case. It changes it to 12% from the date for pre-judgment, 12% from the date of service of notice of claim or complaint, whichever is earlier, and the post-judgment interest is 12% from the date of judgment. Section 3 amends the insurance laws to, it actually allows a third party, allows a person to take action against a third party liability insurer for not complying with the good faith law with regard to insurance companies. And Section 4 amends that same section to allow triple damages against any insurer who violates any of those sections. And then Section 5 prohibits the subrogation of, I believe it's medical damages for if the damages are less than $20,000. So the insurance company would not be able to collect for the damages that are paid out up to $20,000 if there is a settlement. So anything over 20,000, they would be able to recoup their losses or recoup their payments. There is an amendment that was prepared by the main trial lawyers that was actually distributed back in April, and I sent it around to you again. And it's not an amendment I drafted. I'm happy to walk you through it if you want, or maybe the sponsor can walk you through it, or I don't want to step on anybody's toes by walking you through it.
Let me just check in with the bill sponsor. Representative Harnett, would you like to present the amendment?
I am comfortable with Peggy explaining the amendment. It's fine.
Great.
Thank you.
Thank you.
Thank you. So the amendment amends Section 1 and changes it to 10% instead of 12% annual interest. That's pre-judgment interest as well as post-judgment interest. So rather than tying it to U.S. Treasury bills or any other anything else that changes, it actually establishes it at a 10% annual percentage rate. Although the amendment strikes out the new language in Section 3, what that really does, it means take Section 3 out of the bill completely, as well as Section 4. So you're not going to be amending that good faith statute. It's probably not called good faith statute, unfair claim settlement practices. So this would not be amending that anymore, but it does retain the subrogation on certain casualty insurance policies when the damages if it allows subrogation if the damages exceed $20,000. So that was part of the bill.
Thank you, Peggy. So in a nutshell, the changes that are proposed by the amendment relative to the statute rather than relative to the bill are that it increases pre and post judgment interest to 10% per year, and then it restricts subrogation rights, eliminates them for claims under, well, judgments or settlements under $20,000.
Right.
Okay. Thank you. Let's see, we have a couple of hands raised. I'm going to ask Representative Babbage, I'm going to give the floor first to the bill sponsor, Representative Harnett.
Thank you, Madam Chair, and thank you, Peggy, for that analysis. I will be brief and then point out something that we received this morning. This bill simply attempts to bring Maine into sort of accord with other New England states regarding pre and post judgment interest. Not all, there are states with different rates, but there are states with higher rates as well. I would note, and I believe you received this, Peggy, we received a letter today from the representative of the superintendent of insurance about the impact, the fiscal impact that this might have on insurance rates. Is that something that you received?
I don't see it.
Okay. I might ask, let me just pull it up on my screen.
Okay.
And I believe they have a representative here, an
Mr.
actuary,
Schott, I believe.
who might be able to explain that. So I just think in fairness to the committee, they should have this information. So if we could have the actuary moved over to explain the concerns of the department.
I've just brought him over to the panel.
Thank you. So my request would be for Mr. Schott just to explain the letter that was circulated by the superintendent of insurance this morning.
And Mr. Schott, are you able to activate your audio and video?
Good morning. Can you hear me?
We can hear you. Are you able to activate your video as well?
There we go.
Oh, brilliant.
I love technology. I can take a stab at this. We also have Sandra Darby, who's our actuary. If you have any specifics on the math part of this, but yeah.
I've just invited her to join the panel as well. Okay, go ahead.
Thank you. So yeah, we submitted a letter, which we did a little bit of analysis on what the subrogation part of the bill, what the impact might be on premiums, and basically found that there's likely to be a 13% increase in the med pay part of premiums, which is a small part of the overall premium amount, and likely to be a 0.5% premium increase overall on auto premiums. So hopefully that makes sense, and Sandra could explain that a little bit more if you need more explanation.
Thank you. Thank you very much, Mr. Schott. Do committee members have questions for Mr. Schott, or should we turn to Sandra Darby for a further explanation of the impact on premiums? Okay, let's see. I'm going to see if there are questions for you first, Tim Schott. So Representative Moriarty, do you have a question for? Okay, go ahead.
Yes, I do. Thank you, Madam Chair. Mr. Schott, good morning. You were with us last time, and you mentioned, or perhaps not you, but maybe it was someone else who filed written testimony, mentioned that there was a change in the law in 2009 relating to subrogation rights, which was then repealed 3 years later in 2012. Are you familiar with that change?
I somewhat, I'm hesitant because I don't want to be inaccurate. I think there was a similar limit on when subrogation was not allowed during that time period that you mentioned, and then it was repealed again, as you mentioned, back in like 2012 or so.
Right.
Yeah.
So was it at $20,000, or are you able to say that, or?
I am not able to say. That sounds correct, but I'm not 100% certain on that amount.
Okay. The next question then is, why was it repealed?
That I couldn't answer. I would expect that there was probably some testimony or some urging that it had an impact on premiums, but I can't answer that much more than that.
Well, do you know if there's anybody in the department that can reach back that far and tell us what the premium experience was and what led to the repeal?
Yes, I can see what I can find out, and I don't know if Sandra would have any information on that or not.
Let's check in with her. Sandra, welcome to the Judiciary Committee. I think you've heard the conversation. Do you have additional information about the premium increases? We're not able to hear you.
Apologize. My first time speaking on the committee. I apologize. I don't have any additional information for the question that they just asked Tim from the 2012 period, because I didn't look that far back on premium increases. What I had done was requested the carriers provide me with data regarding this change of the 20,000, and if they were able to quantify, if they weren't in the last 5 years able to recoup the $20,000 in med pay and how that would affect their premiums for today. And that's the analysis that I provided in the letter.
Thank you. And so the impact is 13% increase in med pay,
correct,
which would be equal to a 0.5% overall increase in the auto premiums.
Correct, on average. And that was I was only able to get data from 50% of the market, because I didn't know when the LD was coming back to the table.
Thank you.
You're welcome.
We'll see if there are additional questions. Go ahead, Representative Babbage.
Thank you, Madam Chair. Mr. Schott, the numbers that you, I think, interpreted from the increases that would happen in insurance regarding, I suppose, being impacted by the pre and post judgment rate changes. Were those calculated at the original bill, 12%?
That we don't have a number for that particular impact of the interest rate. The letter that we submitted basically, I think, explains that that's a hard thing to quantify. It would vary from case to case, year to year, et cetera. So the average rate increases that we provided really are just the subrogation part of the bill.
Okay, thank you for that. And maybe you can clarify something for me. Do you know what the U.S. Treasury bill rate is today or yesterday? I thought I saw it at 5%. And if that's the case, then the post-judgment rate at 5% plus 6, according to current law, would be higher than the proposed amendment. I just wanted that clarified or realized or whatever. Thank you very much, Mr. Schott.
Thank you. Representative Libby, did you have a question or was it answered?
Thank you. It was answered by Representative Babbage's question.
All right, thank you. Committee members, are there any additional questions for either Tim Schott or Sandra Darby? Representative Babbage, did you have a second question or you? That's all right. Thank you. Okay, I'm gonna move you both back to the attendee part of the meeting. Thank you once again for being here today. And committee members, are there any questions for our analyst, Peggy? Go ahead, Representative Moriarty.
Well, Madam Chair, I'll just take a stab and ask Peggy if she knows what the U.S. Treasury bill rate is, and if she has any knowledge of the passage and repeal of essentially the same provision regarding subrogation over a decade ago.
I don't have information about the passage and repeal. I think somebody in their testimony said it actually wasn't there for very long. It wasn't like a long-term addition to the statute before it was repealed, but I did not double check that. And I will look up see if I can find the Treasury bill rate.
Thank you.
It would be the 1 year.
I was going to say 3 months doesn't look very good.
The 52-week rate was 6% as of May 11th.
I thought it went down the following day. I mean, I thought May 11th was a 5 and 6 had been all the previous days.
Yeah, well,
am I wrong on that?
4 at 13 weeks, 4 at 6 weeks, and 6 at 52 weeks.
Yeah. Okay.
All right. Do we all feel satisfied with that information? All right. And then go ahead, Representative Harnett.
Are you prepared to accept a motion at this time?
I was going to ask committee members if they had any additional questions for the bill sponsor. I'm not seeing any, so yes, you can make a motion.
I would make a motion ought to pass as amended.
Is there a second? Seconded by Representative Sheehan. And Representative Moriarty, did you have a question or a comment?
This is part of discussion, I guess, now that the motion has been made. This is what I think we need to know. I guess thanks to Jim, we now know what the Treasury bill rate is, much higher than I had anticipated. I think we need to know from someone who may be in the panel, and I don't know who all is there, what in fact the experience was from 2009 to 2012 when what may have been an identical subrogation provision was enacted and then repealed. If the net effect of the subrogation change was only a 0.5% increase in insurance rates, it's hard for me to believe the legislature would have taken the time to repeal the law that was so freshly enacted, which leads me to believe that the impact was greater than 0.5%. I have no knowledge, but there may be somebody with us who does.
Thank you, Representative Moriarty. And it does appear that there's somebody on the panel who is able to answer that question, and that is Charlie Sultan. And so I will bring somebody in the attendee space, excuse me, I'll bring him over to the panel.
Thank you, Senator Carney. Members of the committee, my name is Charlie Sultan. I am here on behalf of the Maine Association of Insurance Companies. I was involved in both the 2009 and the 2012 and legislation. This issue, because it's in Title 24A, has always been handled in the insurance committee. It's usually not in this committee because it's not part of the usual jurisdiction of the committee. It was passed in 2009 through an effort from the Maine Trial Lawyers Association. It was repealed 3 years later Representative Moriarty, because there was a change in the makeup of the Maine legislature at the time. The majorities flopped, and switched over. But we did present evidence at the time of the increase. In a letter I wrote to the committee submitted on Saturday, I included some information on the effect of those changes that showed the decrease in the recoveries that were made. And I think what you need to focus is not on the overall insurance rate, because there are so many different factors in an insurance policy. It covers fire, it covers casualty, it covers property, and so on. But it does on med pay, which is one of the most inexpensive portions of your coverage and is required at a minimum of $2,000. An increase will be, as the Bureau said, about 13%. And there was a significant increase at the time. Most recoveries for subrogation and med pay are under $20,000, so it significantly impacts the rate for that coverage that you are going to have. Our argument is that the at-fault party ought to pay it, and we provide the money to our insureds first, and then seek it from the at-fault party, and that's how it works. But it does significantly impact the amount of recoveries.
Representative Moriarty, did you have any follow-up questions?
Not at this time. Thank you.
Committee members, are there additional questions for Charlie Sultan? Go ahead, Representative Babbage.
I'm sorry, am I being heard? Yes, I am. Actually, my question is not for Mr. Sultan. It's for a member of the Maine trial lawyers, if anybody's in the panel that proposes the amendment. Thank you, Mr. Sultan.
You're very welcome. Thank you.
Thank you. Yeah, thank you, Mr. Sultan. Are there any questions for Charlie Sultan before we send him back to the attendee portion? Go ahead, Representative Harnett.
Thank you, Madam Chair. Nice to see you again, Mr. Sultan. Do you disagree with the conclusions reached by the Department of Insurance with respect to the 0.5% increase in their actuarial standards that this would have on the total auto insurance bill?
On the total insurance, I can't, because I haven't done those calculations. But again, we're looking at an insurance policy that covers a large amount of risk on your behalf. So this would affect the subrogation part only. So you can look at it the two different ways: the 13% increase for MedPay, and then as well as their overall calculations. Sandra is a wonderful actuary, and so I can't doubt her calculations based on information she has.
Thank you.
Committee members, any other questions for Charlie Sultan? Senator Keim, go ahead.
Thank you. Yes, I just was hoping you could explain. I'm sorry, I seem to have missed that. But 13% for MedPay, so I understand the change in the overall auto insurance rates. But what are you? Could you explain again the 13% for MedPay?
Yeah, as I understand it, the Bureau's calculated that that portion of your auto policy that we're required to have for medical pay coverage, which is what we pay as your insurance company to help cover your immediate medical bills. And that would go up 13% if the bill is structure passes.
Okay, thank you.
Thank you, Senator Keim. Any other questions for Charlie Sultan? Go ahead, Representative Moriarty.
Thank you, Madam Chair. This is a question I had jotted down for myself, and I'm embarrassed to have to ask it, but it's better that I know the answer. Mr. Sultan, explain to, if you will, to a rusty former attorney what the date of service of notice is. I understand the concept of service of a complaint, but what is the service of notice?
So So not being a trial lawyer, I will venture what I understand, and I'm sure someone on the panel will correct me if I'm wrong. You can serve a notice of claim right away so that the insurance company and the defendant is aware of the pending claim. The claim then would be served on you, the formal complaint later as it has matured. So a notice of claim can come first. It doesn't always come, but usually it does. And then the complaint is formally served with your allegations and everything later on. So that can be a fair amount of time before, from one point to another. And then you go into the litigation mode and discovery and so on once the complaint is served.
Madam Chair, could I have a short dialogue with Mr. Sultan on this point?
Well,
or one or two more questions, basically.
Yeah, that would be fine. I think that he indicated that this is an area that he's not super familiar with, and we are going to request somebody from the Maine Trial Lawyers Association to join us. But with that understanding, go ahead, and I think he can ask the answer if he's able.
Okay, and I'll keep it as short as I can.
Thank you.
As I understand it, a notice of claim is essentially a letter advising the adverse party that you either are or may be making a claim.
Correct.
And that notice could be sent a week after the automobile accident or the personal injury.
Yes.
Would any, in your judgment, would any plaintiff's attorney advise an injured person to settle with the insurance company as soon as a week after the accident?
No.
In fact, isn't there going to be, well, based on your experience, how long a gap is there between the service of notice and the filing of a complaint?
It's going to be some time. A good lawyer will want that injury to, I'll call mature, so they know what the extent of any potential damages are. They want to know what kind of loss of income may have occurred to see how that claim will sort of blossom into a real amount so that the injured person could recover an accurate amount for their lost wages, their injury, the loss of comfort, society, things like that. So it'll be some time.
All right, I think that's as far as I need to go, Madam Chair. Thank you, Mr. Sultan.
You're very welcome. Thank you.
Thank you both. Any additional questions for Charlie Sultan? Not seeing any. I am going to send you back to the attendee space. And I'm misremembering, but was it Representative Harnett? Did you request a representative from the Maine Trial Lawyers Association?
I did, and I believe that is Lori Boxer McCumber.
Okay. Oops. Welcome to the Judiciary Committee, Lori Boxer McCumber.
Yes,
and
welcome. Thanks for the welcome.
Representative Harnett has some questions for you. Go ahead, Representative Harnett.
Thank you, Madam Chair. I was just wanted to ask Ms. Boxer McCumber to address the issue regarding the service of notice of a claim or complaint and why that is significant to have the interest run from the date of the earlier filing.
Right. Well, all cases are highly circumstantial. So I would beg to differ with what I just heard the other attorney saying with respect to always having a lawsuit filed maybe, years or even a year after a notice of claim is served. So let me just kind of go to the basics, and I apologize if this is information that you all already have, but after a crash, a collision, or some type of event, when someone is, often when they're represented, the attorney will go ahead and send a piece of paper that advises the responsible party of the fact that there's a claim against them, and it's served in a certain way on that person. And that person then lets the insurance company that represents them know that there's a claim against them. In some cases, soon after serving that notice of claim and learning about insurance and running an asset check, the person's damages are so extreme that a case will settle soon after the event, even if the person has catastrophic injuries, because there's simply no more money to be had after all the due diligence, background checks and everything like that are done. But in other cases, interest will begin to run on that claim from the time that that claim is properly served on the defendant. And this is so important because often you're dealing with people who have head injuries or who have lost their job. And so they're bearing the costs of their the event, even if it's due to no fault of their own, and sometimes for years. And so, truly, many of us who work in this field have had people that literally can't afford a stamp to send us, documents, and they are putting stuff on credit cards, like they're putting their co-pays on their health visits on credit cards and paying 15 to 18% interest on things. And their prejudgment interest is only running at a much lower event for years, or much lower interest for years. And so the reason why what we want to do here is so important is it really is, basically properly compensating someone for the time that goes by when they can't actually settle their case because they're still treating, or there's still uncertainties about what their medical endpoint is going to be, and the time of the event. Hopefully that answers the question.
Thank you very much. It does.
Thank you. Committee members, okay, Representative Moriarty, I will recognize you for a question. I would just like to indicate that I feel like we're venturing back into the territory that we covered in the public hearing on this bill. So if you could ask just one question, please.
Yes, Attorney Boxer Maycomber, is the 12% per annum Treasury bill rate equivalent to the rate that was in effect on the date of injury, or is it the rate from the previous calendar year?
I have to look at the actual language of do you have the actual bill in front of us?
It says 12% per annum, but we just had a quote of today's rate, but I suspect it's not the same as the past calendar year's rate.
Right. So I think that wouldn't it be consistent with what we previously have in place, which would be for the last full week of the calendar year immediately prior to the year in which prejudgment interest begins to accrue. So it would be running from the time of service of the notice of claim. Is that what your question is?
No.
Okay.
Does the Treasury bill rate reflect the rate in effect on the date of the car accident, or the prior calendar year's average of the Treasury bill rate?
I think you're asking about what currently applies?
Yes.
Under our current law. Yeah, I mean, I think it's laid out in the statute. It doesn't, I'm looking at.
I don't see it.
So it's the last full week of the calendar year immediately prior to the year in which prejudgment interest begins to accrue. So prejudgment interest begins to accrue when the notice of claim is served. So it really depends on the date of service of that notice of claim. That's my
Sorry,
understanding.
we're passing in the dark here, I think.
Representative Moriarty, are you able to vote on this bill without tracking that information down, or is it something that you feel like you need to know the answer to in order to weigh in on the legislation?
No, I would not hold up the vote, but I do think it's a critical point.
Thank you.
So I would love to be able to answer it if I'm missing your point, because I think you're asking, when does it start accruing, right?
No. I'm saying, what is the percentage rate that applies? The rate on the date of injury or the average rate from the prior calendar year? Or some other measured period
Right,
of time?
and I think isn't it the rate that is in effect based on when the notice of claim is actually served? So it's dependent on that.
I don't know that answer. So that's why I'm asking the question.
That's what I'm saying. If you look at the actual text of 1602B, I think it's spelled out for us in that language of the statute, that it's saying that the 1 year United States Treasury bill rate means the weekly average 1 year constant maturity, blah, blah, blah. And then it says for the last full week of the calendar year immediately prior to the year in which prejudgment interest begins to accrue. So prejudgment interest begins to accrue on the day that the notice of claim is served. So then you would look, that may vary. If the event occurred on June 1st of 2021, but the notice of claim wasn't served until June 20th of 2022, you'd be looking at the calendar year for the date that the notice was served, and you would be looking at the last full week of that calendar year. So if it was served in 2022, you'd be going to the last full week of the calendar year of 2021.
Okay, so for notices of claim served this year, the rate is that which was in effect in the last week of December 2020.
2020. That would be my read of 1602B.
Okay, so the rate changes once a year based upon the final week of the previous year.
If that's when prejudgment interest began to, yes.
Okay,
so it's dependent on when the notice of claim is served and then going back to the year before.
Right. That does answer the question. Thank you.
I'm sorry that we had a miscommunication. I know it's complicated and sometimes the statutory language is not all that clear. And that's part of the reason why it would be so helpful to have a concrete number, right? Because this is confusing for people, right? So why not know exactly what it is that's running and know that it's a 12% or 10% or whatever it may be, or 15%.
Thank you.
Thank you both. That was a helpful dialogue. Go ahead, Representative Babbage.
Thank you very much, Madam Chair. Hello, Ms. Box-Maycumber. I appreciate you. I read this and the calendar year part actually escaped me. So even though the Treasury bill rate gets determined at 3:30 every afternoon by the Federal Reserve, the week that we're determining this rate at currently is a once-a-year phenomenon that's appropriate for application. My question is, if according to treasury.gov, for the last 3 days, it's been at 5%, and prior to that, it's been at 6%. 3 days last week, it was 6. 2 days, it was 5. The numbers really don't matter too much, except that the change that you're asking for in section 2 for post-judgment is actually probably lower than the actual rate if current numbers are similar to last December's rates. I don't know what last December's rates are. Does it matter that, were you trying to achieve an increase or simply a stable rate?
Right. No, I think we were trying to achieve an increase. And I thought historically the numbers have been lower with that annual Treasury rate. And then we started with the 12% request.
Okay. But you understand what I'm pointing out.
I absolutely do. And certainly we would not want to have an adverse effect and hurt this constituents that we're seeking to support.
Okay, so, thank you, Representative Babbage. And see, Representative Harnett, go ahead.
And I'll be very quick, I hope. The amendment sets post-judgment and pre-judgment interest at 10%. It removes all of the language regarding the treasury bills and what the rates are. It establishes a stable rate. So I don't know if that helps Representative Moriarty. It may, in some instances, result in a lesser interest rate to the injured parties with the post-judgment, which was currently the treasury rate plus 6%, but it eliminates that and just looks at a stable rate of 10%. So I think a lot of the discussion about the rates is taken off the table by the amendment being proposed by the bill sponsor. I hope that helps.
Thank you, Representative Harnett. Senator Keim?
Thank you. Yes, I had a question for Ms. Boxer Maycomer, just to help me understand so for $20,000 is not, the insurance companies can't recoup $20,000 of the money that they would have paid out. And is the main trial lawyers in favor of that, because then that increases the amount of money that would be coming in any settlement, and so therefore it makes a case for
Senator Keim, I'm going to ask you if you can deactivate your video and try re-asking your question just with audio on, because we're not able to really understand what you're saying. It's just breaking up.
Yeah, I was just wondering about the $20,000. Can you hear me now?
Yeah, yes, I can. It's much more clear.
No?
Thanks.
Okay. Oh, you can. Okay, thanks. So the idea of removing $20,000 that the insurance companies are not able to recover in the amount of money that they have to pay out, is the reason the main trial lawyers are in favor of that is that then it makes clients more able to get a lawyer because they have more money.
No, so I think here's the situation. It's the proposed amendment to the subrogation statute is driven by a couple of different things. So it's not that insurance companies are being deprived of $20,000. So what this is doing, let me see if I can simplify it. So right now we have so many cases clogging up the courts, and a lot of them are small cases that are very difficult to settle. So if a case is valued or has a settlement value of under $20,000, what this allows to happen is an insured who's already paying for premiums would be allowed to say to their own insurance company, if I've purchased medical payment coverage and I needed that, and I used this thing that I've been paying for over the course of years and never using, and if I use it for this one car crash and you paid out, like in Maine, most people only carry $2,000. So this is basically saying that if they receive a settlement of under $20,000, or I can't remember if it's $20,000 or $19,999, but that they don't have to pay that $2,000 back. And it allows them to maybe get just a little bit more money in their pocket to feel comfortable with that settlement, and also get a remedy that's just for the person. So regardless of whether they're represented or not, it gives them the right not to have to pay back that additional money that they've already they've been paying for the benefit of that coverage, usually for years too. So it just makes it a lot easier to settle cases, keep cases out of court, or lower the number of cases on the docket. Trial lawyers really don't benefit from this at all. It's really something for Maine people that are already paying premiums on their policies. We benefit from it in that we're able to help people and, you know, serve our role in the state as helping as, you know, ambassadors to justice, but there's no like kickback in it for us as the Trial Lawyers Association. It's really for the benefit of Maine people and to get them fully compensated quickly for their cases and let them move on. And I also would note just something that I've, you know, when I take these small cases, because my cases can range, you know, from millions of dollars to some of these smaller cases, but I note that a couple of things happen. You know, people are sometimes when they get a certain amount of settlement, they're able to go off public benefit programs more quickly. And if part of their settlement or part of their coverage during their recovery period, if they've been injured, has come from Maine Care, they're able to, you know, pay Maine Care back and move on with their lives or go off a program like that.
Ms. Maycomber-Boxer, I'm going to ask you to stop there because I think you've gone beyond the question and this is really a work session.
Sure.
We do sincerely appreciate the additional information you've provided. I just, I'm cognizant of
course,
of the role that we're all in here. Committee members, is there any final question for Lori Boxer Maycomber before we send her back to the attendee space? I am not seeing any. Once again, thank you so much for the information you provided today.
Thanks for allowing us the addition.
Committee members, is there any more discussion or is the committee ready for the vote? Go ahead, Representative Moriarty.
Madam Chair, I just wanted to advise you and Co-Chair Harnett and everyone how I'll be voting in this case and why. I have a couple of problems with the bill as amended. First of all, I think the prejudgment interest should begin to run upon the filing of a complaint and not upon the service of notice. The service of notice can be done within days of a very serious injury. And in those cases, it would be utterly irresponsible, if not unethical, for an attorney to advise a client to settle prematurely until the full scope of the injury, including loss of wages and other factors, has become manifest. I'm okay with the 10% of prejudgment interest, assuming that it begins to run on the date of the filing of the complaint. I'm also okay with the proposed change to the post-judgment rate of interest. I do not agree with the unavailability of subrogation for medical payments less than $20,000. So that's my position.
Thank you so much for sharing that, Representative Moriarty. Would anybody else like to discuss the bill? Sounds like we are ready for the vote. Oh, do we have a motion?
Yes, we do.
Okay, thank you. I've got so wrapped up in the discussion. And so, Representative, I'm apologize, but the motion is ought to pass as amended. And we are moving forward with the committee vote, and our clerk, Ms. Panett, is here. You may call the roll.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Galgay-Reckitt. Representative Galgay-Reckitt is absent. Representative Hagan. Representative Hagan is absent. Representative Evangelos. Representative Evangelos is absent. Madam Chair, I have 5 members voting in the affirmative, 5 members voting in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. And now I'll turn to those who voted in the negative. I don't know whether there will be multiple reports on this. Representative Moriarty, I'll start with you. Is your report ought not to pass, or is it ought to pass as amended with the amendment that you described earlier?
Yes, the latter, Madam Chair. It would be ought to pass as with a revised amendment, as I outlined.
Thank you, and thank you for explaining it so clearly earlier. And Senator Keim, what is your report?
Mine is ought not to pass.
Thank you. And then for those who are on the screen, Representatives Libby, Poirier, and Thorne, what is your report?
Ought not to pass.
Okay, all 3 of you, thank you. And with that, we'll close the work session on LD 1160. Thank you, everyone, for your participation in that discussion, and thanks to those in the attendee space who were able to join us and answer our questions today. I see that Representative Evangelos has joined us. Is he able to cast his vote? He was just a little late getting to us.
Good morning, everyone. I would need to get up to speed. I literally, I've been here for a while, and then I had some business to take care of, and I just checked in again. I don't want to vote on what I don't know what I'm talking about, so I'll try to. Soupy will send me the sheet, and I'll do my homework.
Thank you so much, Representative Evangelos. All right, and so now we'll open the work session on LD 737. And again, as a reminder to those who are attendees, the order that in which we'll take up bills is posted in the chat. It's, I think, the first post.
So LD 737 is an act to increase the value of property exempt from attachment and execution. The bill amends Title 14, Section 4422 to change many of the exemptions that are already in statute. And these are exemptions from both bankruptcy, but also attachments. If there's a judgment against somebody, the person would be able to keep this amount of whatever their assets were in order to keep living and keep going on and not being totally destitute. So rather than identifying everything that the bill changes, and it was a percentage increase based on the last change and what I believe what the Consumer Price Index has changed since then. It covers the residents, motor vehicles, clothing, jewelry, tools of the trade, just about everything. And then it also added in a bank account exemption. And there was a lot of testimony on both sides of this, and Representative Tepler worked with a lot of the interested parties and was able to put together an amendment that she sent yesterday and we shared. And I see that Representative Tepler is here, so maybe it's better if she actually explains the amendment, because I bet she understands it really well.
Thank you very much, Peggy. Representative Tepler, welcome to the Judiciary Committee. Pleased you can join us today, and if you could explain for us the proposed amendment, we'd appreciate that.
Thank you, Senator Carney, but I'd actually, and I hope you'll forgive me, like to ask Mr. D'Alessandro who convened the stakeholder group that worked on the amendment to present the amendment to you. I would say that he is the best person for you to get all the details of the amendment. The stakeholder group included both the creditors and the consumer advocates. So Mr. D'Alessandro did convene that group and I believe wrote the final amendment. So can we invite him in, please, to present that amendment?
Thank you very much, Representative Tepler. He has just joined us.
Great.
And Frank D'Alessandro, welcome back to the Judiciary Committee. And if you can proceed with explaining the amendment, and if you could give us a little information about the process and who participated, and then explain the amendment, I think that would be helpful to the committee.
Sure. After the public hearing, we convened a stakeholders group. It contained a private practitioner who represents creditors. It included a Chapter 7 trustee, a Chapter 13 trustee. It included the representative of the Maine Bankers Association, the Maine Credit Union, and FAME. It also included a representative for legal services for the elderly, Pine Tree Legal Assistance, Maine Equal Justice, and 2 private practitioners who represent debtors. And so we looked at the bill, and also this is not just my work product. In fact, there are other people who were involved in the group who were much more involved than I was. But this is where we landed as a compromise. The first part of the bill is significantly changed from what was originally presented. It goes back to the language in the current statute and basically just increases the exemption amounts. And then there's the various increases in exemption amounts that were agreed to by all the stakeholders. And so that this represents where we are, where we landed. And I could answer any questions.
You're muted, Senator Carney.
Thank you. Thank you very much. I will turn the virtual gavel over to Representative Harnett because I need to check on the status of my bill in another committee. And I will be back when I'm able to rejoin. Thank you.
Thank you, Madam Chair, and thank you, Mr. D'Alessandro, for being here to present the amendment. Before opening it up for questions from the committee, you outlined the parties that were part of this process. Is this an agreed upon document from that group working together?
Yes, that's my understanding, yes.
Okay. Thank you. Are there members of the committee with questions for Mr. D'Alessandro regarding the amendment? Or would you like him to actually walk through the dollar amounts and explaining how we got to where we are today? So am I correct that there are no questions for Mr. D'Alessandro? Seeing none, are there questions for the committee analyst or the bill sponsor? Seeing none, is there a member who's prepared to make a motion on LD 737? Representative Moriarty.
I move ought to pass as amended.
We have a motion ought to pass as amended by Representative Moriarty. Do we have a second? Seconded by Representative Sheehan. Is there discussion by committee members? Seeing none, we have a motion and a second ought to pass as amended. I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime.
No.
Senator Kime votes no. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 7 members voting in the affirmative, 4 members voting in the negative, and 2 members are absent.
Thank you very much, Committee Clerk Panett, and we will.
Excuse me, can I just ask Representative? Oh, okay.
Those who voted in the negative, is your report ought not to pass?
Correct.
Thank you. And did you have a question, Senator Carney?
Yes, my apologies for interrupting. I think that Representative Reckitt's vote may not have been
Yes, you're absolutely
in the
right.
final tally. Thank you.
Would you like me to recall what I mistakenly said before?
Please.
Mr. Chair, I have 7 members voting in the affirmative, 4 members voting in the negative, and 3 members are absent, for a total of 14.
Thank you.
Thank you, Madam Chair.
That resolve your question, Senator Carney? My apologies. With that, I would thank the bill sponsor for bringing the bill forward and close the work session on LD 737. And Chair Carney, how would you like to proceed at this point? I'm sorry, Supi, you had your hand up?
Yes, we need to know the minority report, please.
It was ought not to pass.
I'm sorry. Thank you. I did not hear that. Thank you.
Thank you so much, Chair Harnett. I will at some point be called to EUT to introduce a bill. And if you're able to lead the work sessions, I would very much appreciate it.
Absolutely.
Thank you.
Madam Chair, I will now open the work session on LD 461, an act to allow the reduction of a main care lien. I would invite the bill's sponsor, Representative Cardone, to be moved over as a panelist and turn the proceedings over to our analyst for her analysis.
Thank you. LD 461 is an act to allow the reduction of a main care lien. And this bill amends the statute governing the DHHS right to recover the cost of benefits that are provided through main care, through a statutory lien against on the proceeds of any kind of award or settlement. So if main care recipient is injured and main care pays those medical costs, and then there's a settlement from whoever the person is at fault that caused those injuries, then main care has a lien on those proceeds. And the purpose of this bill is to require that the main care, the amount that main care is going to recoup is reduced by a pro rata share that would cover the reasonable attorney's fees in getting to that settlement or that judgment. And it's not that those reasonable attorney's fees would then be turned over to the private attorney that took the case. It means that the injured party would be able to retain that much of what otherwise main care would cover in their lien. The U.S. Supreme Court has identified that these liens for Medicaid and main care cannot include more. They can't recoup more than the amount of the settlement or judgment that is identified to be for medical costs. So when you have a settlement or you have a judgment and main care is involved, the attorneys are going to have the settlement or the judge identify how much of that settlement is for medical costs and how much is for any other kind of damages or injuries that aren't covered by medical costs. And I think that's what this says. Right now, the main care lien, the main care settlement amount cannot be reduced to cover attorney's fees. Hopefully I explained that well enough.
Thank you very much, Peggy. And we have been joined by the bill's sponsor, Representative Cardone. Representative Cardone, welcome back to the Judiciary Committee. I know you were in another meeting. Thank you for coming over to talk about LD 461. Do you have anything to add to the report of the analyst?
I do not.
Okay. Did she accurately describe what it was you were hoping to accomplish and the reasons for it in the statute, in the LD?
I think so. I was in transit for most of what she said, so I have to admit I didn't hear it.
Okay. Are there questions? Well, let me ask a question, Representative Cardone. I believe you said that it could actually increase the amount of money recouped by main care. Could you explain what you meant by that? Because we might be looking at a fiscal note.
Oh, you're definitely looking at a fiscal note. And in fact, the author of the note will be Luke Lazur, who is the OFPR analyst who usually works with HHS, but because this is main care, it's on Luke to do the note. And I have had some discussions with him. This is a very difficult fiscal note to put an accurate value on because of so many unknowns. One of the unknowns is if you pass this bill, it becomes more viable. More claims are viable for recovery. More money will go into the pockets of the people who were injured in an accident or an incident, who have main care as their primary care insurance, as a primary insurance. With more money going into their pockets, it makes it more viable for attorneys to actually bring claims on behalf of these people. But I can't tell you, and again, we had this long conversation with Luke, really nobody can tell you at this point how many more claims you may see. It will be able to look at it in retrospect after a number of years to see where the increase has been. But that is the hope, that with the attorney fees piece of this passed, more claims will be viable. I do know the fiscal note will not contain a decrease. The fiscal note will not account for the language that decreases the main care claim to the proportion of the settlement that has to do with
recovery of medical expenses, because that is the federal law anyway. So it's what the state, even if the state has been collecting more money, they'll be collecting less, but they should be collecting less anyway. So the fiscal note is not going to reflect that part of this bill. It will only be with respect to attorney fees, and it's likely going to reflect only what the department would have to pay out. It's not going to reflect what we hope is a very significant possibility of increased revenues for the department.
Thank you. And can you explain how this would benefit people with smaller claims in terms of accessing legal representation?
Sure. I think we went through this at the public hearing, but I'll just as a reminder, when you have, first of all, with any other health insurer, they reduce their lien by a proportionate amount, usually a third, but by a proportionate amount, to allow for more money in the pocket of the victim of the tort, the injured party. They're in fact paying a proportional, by reducing their lien, they're attributing it to paying their proportional share of the attorney fees. So they are reimbursing the injured party for their proportionate share. So that means there's more money going into the pocket of the injured party. Generally speaking, with attorneys who are taking cases on personal injury cases on what's called a contingency fee rather than an hourly rate, a share of what they recover. The attorney isn't going to take a case where the client is left with no money or is left with getting less money than the attorney gets. It's just not, you just don't do it. It's not considered a viable case. So anything that's going to put more money in the pocket of the injured party is going to make the claim more viable for the attorneys to bring and to collect on behalf of main care as well as their own client, the liens, the medical liens.
Thank you for that refresher, Representative Cardone. Are there questions from committee members for either the bill's sponsor or the committee analyst? Seeing none, I would end Representative Babbage.
Thank you, Mr. Chair. Good to see you again, Representative Cardone. I just wanted to follow up. Insurance companies act out of self-interest, just like all business. So my question is the reason that commercial insurance, health insurance companies do not have a parallel to what we're talking about here with main care is because they do feel that more cases will be brought in which they will collect?
Well, in the case of private insurance companies, and I think I'm right about this. If Mr. Jabbar is on, if Mr. Jabbar is listening in, if he knows that I'm saying anything incorrect, I hope he'll raise his hand and chime in. But most insurance companies or lien holders are bound by something called the common fund doctrine, which is a doctrine. It's judicial law. It isn't statute, but it's a doctrine that says that if you're in pursuit of a common interest, you're obligated to pay into the pot for those expenses. So under the common fund doctrine, if Anthem or Cigna or whoever the workers' comp mimic is riding on the back of the attorney who is pursuing the claim, which would include their lien, under the common fund doctrine, they are obligated to pay in for their share of that work to recover their lien. The only insurer that is not obligated or that doesn't do it is MaineCare. So people who have MaineCare as their primary insurer are automatically penalized in that they can't get a contribution. They aren't guaranteed a contribution from MaineCare to help them in pursuit of being made whole as a result of their injury.
Thank you for that answer. Thank you, Madam. Mr. Chairman.
Thank you, Representative Babich, and thank you for the response, Representative Cardone. Representative Libby.
Thank you, Mr. Chair. My question is neither for the sponsor nor Peggy. I'm wondering if there's someone from the department tuning in that could answer some questions. The statement that this would increase revenue for the department, that would likely increase revenue for the department, is in direct contrast to what the department stated in their testimony. I see financial losses, increase in staff time, that it could be more work for the courts and a substantial delay in MaineCare recoveries. So there's a lot of conflict there between what I'm hearing from the sponsor and what I see in the testimony from the department. So I wonder if someone could address that from the department.
I am looking at the attendee room and do not see anyone from the department, but I don't know all of the names here. I'll ask if there is anybody from MaineCare who is in the attendee room who would like to speak to this during this work session on LD 461. And I do not see anyone, Representative Libby.
Well, thank you for trying.
Yep. I did note that the bill sponsor made reference to Jason Jabbar, who could answer one of the questions that was posed. So I would ask the committee clerk to please move over Mr. Jabbar. And Mr. Jabbar, I think I always mispronounce your name, and I know I must because I pronounce it two different ways every time I introduce you. So if you could activate your audio and let me know how to pronounce your name.
Good morning. I've been called all kinds of different things, but Jabber is fine.
Okay.
Thank you.
Representative Cardone indicated that you might be able to discuss the I guess would be aspects of the common fund doctrine more fully.
Yes, I'm happy to answer any questions. Also, just to answer one of the other questions that Representative Cardone was trying to respond to is, I think one of the questions asked why private health insurers either don't or do treat it similarly. And I'm not sure if this responds to the question, but the common fund doctrine does apply to private health insurers that are regulated under the state of Maine. The only private health insurers that are not under that umbrella are so-called ERISA self-insured plans because they're not covered by Maine state laws that regulate insurance. But any private health insurance plan in the state of Maine is obligated by statute to reduce its lien to reflect factors that diminish the value of the case and are required to pay it pro rata their fair share of the recovery fees and costs. Medicare does the same thing. The Veterans Administration does the same thing when they're recovering the reasonable value of medical services that they provided for a settlement. So we're seeing this in every type of case, but with MaineCare, effectively what they're doing is they're getting the benefit of the free labor provided by the lawyer. That labor is paid for by the MaineCare recipient who has to absorb all the costs of the attorney's fees, which makes it harder to settle their cases. And one of the points that Representative Cardone made is that by requiring MaineCare to pay pro rata its fair share of the recovery fees and costs, we're going to be able to settle MaineCare recipients' cases easier because, and let me just give an example to illustrate. I have a case where the insurance company is making a top offer of $15,000. MaineCare has paid $9,000 in medical bills. In that case, the attorney's fees are a third, so it's $5,000. That leaves 10. If I pay MaineCare back 100% of its lien, which is what current law allows them to impose, that's $9,000. By the time I reduce from my costs, let's say $200 of costs, I can show $800 into the client's pocket, which isn't going to be enough for him to justify the settlement, which means that's either going to discourage an attorney from taking a case like that, or it's going to require us to litigate it, and it's going to push recovery, which means push reimbursement back to MaineCare down the road. And, you know, especially now with as backlogged as our courts are, and part of what we talked about in LD 1160 is that insurance companies are taking advantage of it.
Mr. Jabber, I want to thank you for that answer. I don't want to start another public hearing though, and that's my fault for asking a broad-based question. And I think you've answered the question that Representative Cardone put forward. Are there additional questions from committee members for the bill sponsor or the analyst? Seeing none, I would entertain a motion. I'm sorry, Representative Moriarty?
I move on to pass.
Now, I've been instructed by our analyst that, and correct me if I'm wrong, that the proper motion ought to pass as amended, because there will be a fiscal note at some point, and that will allow us to vote and not have to revote. Am I getting that correct?
Right. Yes, and definitely bring it back for language review, and it might even require an appropriation section.
Okay. So are you comfortable reframing the motion, Representative?
Yes, I'll change my motion accordingly.
Thank you. So it's a motion ought to pass as amended, recognizing this would be back for language review. Do I have a second? Seconded by Senator Carney. So we have a motion ought to pass as amended by Representative Moriarty, seconded by Senator Carney. Is there any discussion? Representative Moriarty, I see your hand raised. Is that just residual?
It was.
It was, but it's gone now. Thank you. Seeing no discussion, I would ask the committee clerk to please call the roll on the ought to pass as amended motion.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative.
Hey, this is Heather again with the Northeast Trading Company. Sorry. So we figured out the problem here. Because actually left.
I have no idea what that is.
Somebody needs to mute a microphone.
That wasn't Senator Sanborn voting, right?
No.
I apologize. Senator Sanborn is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 7 members voting in the affirmative, 4 members voting in the negative, and 3 members are absent.
Thank you very much. And for those members voting in the negative, is your report ought not to pass?
Yes.
Thank you. And with that, thank you very much to the bill sponsor for bringing the bill forward. Thank you to the committee for its work. And I would now close the public hearing. I'm sorry, the work session on LD 461, which we will see again in language review. Thank you.
So it turns out that Representative Cardone is the sponsor of the next bill too.
And that is LD 785, an act to change the standard for assessing the risk of serious harm.
Yes.
I would turn it over to our analyst and then to the bill sponsor and open the work session on LD 785.
Thank you. So this bill amends the involuntary commitment laws to change the definition of likelihood of serious harm. And the purpose was to be a little bit more forward thinking than the current law allows for taking somebody into protective custody when they aren't already a participant in the progressive treatment program. You had a long hearing, you had lots and lots of testimony, and you've already had a work session on this. And some of the interested parties said, we think we might be able to figure out how to go forward with this. And they have actually produced an amendment for you. And I sent that out and it's posted. And I can share that if you want me to share that on the screen. But the idea is, instead of changing the definition of likelihood of serious harm, go back and look at when a law enforcement officer is taking somebody into protective custody. And the current law says a law enforcement officer can take somebody in protective custody if the law enforcement officer has probable cause to believe that the person may be mentally ill, and that due to that condition, the person presents a threat of imminent and substantial physical harm to that person or to another person. And this bill, the amendment would change it to say that if the law enforcement officer has probable cause to believe that the person may be mentally ill, and due to that condition, the person poses a likelihood of serious harm as defined in 3801 subsection 4A paragraph A, B, or C. So by doing that, it pulls in the broader definition, which includes a reasonable certainty that the person will suffer physical or mental harm as manifested by recent behavior, demonstrating an inability to avoid risk or to protect the person adequately from impairment or injury. So this is probably really hard just talking about it if it's not embedded in your brain, but so it's changing the standard that the law enforcement officer is going to apply when taking somebody into protective custody, rather than changing the definition of likelihood of serious harm. That definition still exists. Everybody would be living with that same definition. It just means that the law enforcement officer can instead look at that inability to avoid risk or to protect the person adequately from impairment or injury. Paragraphs A and B of that definition are really about risk of physical harm to the person or risk of harm to other people. So you're adding in that paragraph C piece that's not currently in the law. My understanding is that Mallory Shaughnessy, who works with a lot of providers, and Kevin Voivodich, who works with Maine Disability Rights, and Simone Mellon from Consumer Services, I'm probably saying that wrong, have all worked on this and are satisfied that this meets their concerns, and they are all here and can respond if you have questions for them.
Thank you very much. And I would just turn to the bill sponsor to see if Representative Cardone has anything to add and express the committee's thanks for the parties coming together to try to reach a resolution that is satisfactory to all.
And thank you, Chair Harnett. I don't have anything else to add. If the I really didn't take an active part in negotiating the alternative language that Peggy has explained. But as far as I'm concerned, if the interested parties are all in agreement that this is a good compromise and that it works to do what they all want it to do, then I'm absolutely on board.
Thank you, Representative Cardone. And Senator Carney, I saw that you had a hand up. Did you wish to be heard?
Yes, please. I actually was hoping that, well, requesting if Peggy could, to me, it would be helpful to understand the amendment. If Peggy, would you be able to screen share 34B section 3801 subsection 4A, just so that we can all kind of have a visual of those paragraphs A, B, and C? Thank you.
Yes, is that big enough?
Yeah.
So
that's very helpful.
Okay,
Thanks.
great.
Can you make it a little bigger for?
A little bigger?
It's a very small computer screen. It's not my eyes, trust me.
How's that?
Much better. Do committee members had the opportunity to review the statute, or would you like a little more time? So Peggy, we are simply importing an existing set of standards over to the law that is being amended, rather than creating a new set of standards.
Right, you're using an existing definition, right. And part of that definition is already in the law that the law enforcement officers apply. And what you're really adding into that is the paragraph C. Okay. Because if you look at the amendment, what we're striking out is presents a threat of imminent and substantial physical harm to that person. That's basically paragraph A, or to other persons. That's basically paragraph B. And so now you're adding this one more piece. There's a reasonable certainty that the person will suffer harm as manifested by recent behavior demonstrating an inability to avoid risk or to protect the person adequately from impairment or injury.
Thank you very much, Peggy. Senator Carney, do you need the screen being shared?
No longer. That was extraordinarily helpful. Thank you, Peggy.
Thank you. Representative Libby.
Thank you, Mr. Chair. I appreciate that many of the concerned parties have gotten together and worked on this amendment. I would be curious to see if the ACLU, who testified originally against this bill, has any feedback on the amendment, because that's one voice I didn't hear mentioned. And so I would value their perspective on this if anyone is available.
Representative Libby, thank you for the question. And I am looking at the attendee room and I do not see anybody from the ACLU of Maine. But what I would suggest, and let me know if this is satisfactory to you, is to invite, and I would ask the attendees who participated in these discussions, who would be the best person to speak to the process and to who was involved, to raise their hand, electronic hand, so we can move you over and that they might be able to address your concern, Representative Libby. And I see that Kevin Voivodich has raised his hand, so I would ask the committee clerk to please move Mr. Voidovich over. And also Ms. Shaughnessy as well. And Mr. Voivodich, are you able to describe the process that led to this resolution and who was involved?
Sure. And I'll let Mallory speak on her end as well. But just on my side, so Kevin Voivodich, Disability Rights Maine. I did keep Simone Mallon of the Consumer Council in the loop on this, and I can't speak for the ACLU, but I have kept them informed of the amendment as it was changed. So, I know they're not in the hearing. I don't know what other bills they're dealing with, but I did keep them in the loop on these issues, and had some good kind of fruitful discussions with Mallory from the folks on her end, coming to an agreement. And I'm happy to speak about the law at all if anyone has any questions, but also let Mallory kind of talk about things on her side.
Thank you, Mr. Voivodich. Ms. Shaughnessy?
Thank you, and thank you, Kevin. Yes, we did have some very good discussions, and really, in not so much sides, but how do we get to the place that we all want to get to, which is, making sure people are protected, but also maintaining, the autonomy that they can. And so this was, I think, a good resolution. Really, all it's doing is aligning the language. There's a disconnect currently in the language, because often taking somebody into protective custody is the vehicle or the tool to get them assessed. But if they have misaligned criteria, it hasn't been working. And I think we came to a good resolution to make it all work together, all the pieces fit together a little bit nicely. So.
Thank you. And Mr. Voivodich, you at the public hearing expressed similar concerns about civil liberties to those raised by the ACLU of Maine in their submission. So I am assuming on your end those have been addressed in a way that is satisfactory.
Yes, because we're only talking about a very specific time frame, the drive of law enforcement to the hospital, at which time the standard for civil commitment would remain the same, as written in the statute. And I think, in particular, the fact that people could be hospitalized, they lose certain rights with that hospitalization. It was very important to us to keep that standard the same as far as a predictive standard. And like Mallory said, it isn't something that should be taken lightly, the police taking them, but you can see the logical argument that if you're in the house and then 5 minutes later you're in the hospital, why is that standard not aligned to get the person assessed at the hospital? So I certainly, I think Mallory and I were able to come to agreement on that piece, that kind of, where we think the law could be aligned, but it still protects the ultimate civil liberties of the person from going into the hospital.
Thank you. Representative Libby, it was your question. I don't know if that helped or if you have additional questions.
It helped. I would have wanted to hear from the ACLU, but if they're not here, they're not here.
Okay, thank you. Are there additional questions from committee members for the bill sponsor, the analyst, or some of the parties who negotiated the amendment? Representative Libby, is your hand still up?
It is simply up to request a corner caucus before we move to any motion or vote.
Okay, why don't I get a motion in front of us, and then can we go to the corner caucus at that point? Okay. Seeing no additional questions, I would entertain a motion. Representative Babbage.
To pass as amended, Mr. Chair.
A motion ought to pass as amended by Representative Babbage. Do I have a second? I'm going to look at my other screens. No, Representative Moriarty. I have a motion ought to pass as amended from Representative Babbage, seconded by Representative Moriarty. And at this point, Representative Libby, you may commence your corner caucus. Do you know how much time you would need?
5 minutes should suffice.
Okay, thank you very much. We'll regroup at 11:53, if my math is right. And in the interim, folks should feel free to shut off their video and mute their microphones, because we still will be live on YouTube. See you in 5 minutes. Okay, committee members, you can hear me, but not see me. A co-host has stopped my video, so whoever that co-host was who decided I was getting too much FaceTime, if they could please allow me. I think I know who it is.
Sorry, I was looking at the top of your head as you were talking on the phone, and you have a very nice head, but I thought he asked everybody else to turn off their video, so I'm going to turn his off.
I was
I'm
just
sorry, Tom.
sharing the top of my head with the YouTube universe, but thank you very, very much. So if committee members, as they return, could please activate their video and audio, and we have a motion ought to pass as amended, and that motion has been seconded, and this is on LD 785. Is there any discussion amongst committee members? Senator Carney.
Thank you very much, Representative Harnett. I would like to speak to this motion because this to me was one of the most moving and actually saddest public hearings that we've had this session. We heard about the really compelling situation that family members found themselves in, and also that people who were concerned about being wrongfully hospitalized. And what we've got here in this compromise is really all of the parties coming together with a lot of compassion and actually, I think, a lot of intelligence in finding a way to address the problem while protecting the interests of everybody involved, making sure that family members have a way to keep their loved ones safe, and also protecting people who have mental illnesses who might be involved with law enforcement or with the healthcare system. And I just want to express a lot of appreciation actually to Mallory Shaughnessy, Kevin Voivodich, and the others who worked on this fix. It's really powerful that they were able to come together. And I think it's really important for us to try to all get behind this so that we can fix this by passing this bill. Thank you.
Thank you very much, Senator Carney. Are there additional comments? Representative Sheehan.
Thanks, Mr. Chair. I'd also like to speak briefly to this. This was an incredibly difficult public hearing for me. I found all of the testimony wrenching, especially the testimony from grieving and worried family members. But I should say that my tendency is to protect people's civil rights, especially folks who are perhaps not fully able to represent their interests. So with a lot of difficulty, I was prepared to vote ought not to pass, but I'm inspired by the work that was done. And I hope that y'all will consider supporting that great work.
Thank you very much, Representative Sheehan. Are there additional comments or discussion from other committee members? Seeing none, I would ask the committee clerk to please call the roll on the ought to pass as amended motion on LD 785.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
No.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Galgay-Reckitt. Representative Galgay-Reckitt is absent. Representative, that's it. Excuse me, Representative Hagan. Representative Hagan is absent. Mr. Chair, I have 8 members voting in the affirmative, 3 members voting in the negative, and 3 members are absent.
Thank you very much, Committee Clerk Panett. So the motion to pass, ought to pass as amended on 785 carries. I would like to thank the bill sponsor for bringing the bill forward and particularly extend my thanks to all of the advocates who started on opposite sides of this issue, coming together to a very reasonable decision that protects the interests of all and those of concerned family members as well. So with that, I would close the work session.
Mr. Chair,
Yeah, I'm sorry.
just for the heck of it, minority report.
Minority report
Not to pass.
Ought not to pass. Thank you very much, Representative Thorne. I was doing so much better at that today, but still far from perfect. So thank you for that reminder. And with that, I will
That's what
close.
I'm here for.
Thank you. The work session on LD 785. And now turn to LD 681 and open the work session on an act clarifying the removal process of individuals from certain facilities not governed by Title 14 of the Maine revised statutes. And I understand that there is an amendment from the bill sponsor, who I believe is working his way over to our committee. But perhaps in the interim, I could turn it to our analyst. I have just been told Senator Libby is on his way. Peggy, have you had an opportunity to review the amendment? Because I don't want you to have to provide your full bill analysis, given that it seems to be a rather major change.
I appreciate that. Thank you. Right. So this amendment creates a task force to study safe and stable housing in lodging facilities. I'm trying 8 members appointed, some by the Senate President, some by the Speaker of the House, and then some interested parties, as well as the Director of the Maine State Housing Authority or the Director's designee. And the duty would be to review landlord-tenant statutes, licensing statutes pertaining to lodging facilities that are inhabited over 30 days, but less than 365 days, and any other relevant statute, legislative history, licensing procedures, and law court cases, and develop a plan to ensure the safety and stability of clientele housing in these facilities.
Thank you very much, Peggy. And I've just been informed that the bill sponsor who did want to address the committee is delayed. So I would ask for, in the interest of efficiency, entertain a motion to table so we can move on to our next work session and then rejoin this after we conclude our next work session. And is that a motion to table from Representative Libby? So motion to table from Representative Libby. Do I have a second? Representative Babbage. Motion to table. If we could, all those in favor of the motion, please raise your electronic hand.
Mr. Chair.
Yes, Representative
May I
Thorne.
ask a procedural question?
Yes, you may.
We used to, in this committee, take a roll call on even tabling motions, and somehow we got onto electronic hands. Has that been verified that that's a acceptable procedural voting method?
I believe that it has. I believe when we met in person, we did it with a show of hands. It's really just a matter of efficiency.
Okay, thank you. I just wanted to clarify.
Okay, and do you have a vote on this, on the motion to table, Representative Thorne? Okay, I think I see everybody has voted in the affirmative. You can put your hands down. This is tabled until we conclude our next work session, which is on LD 478, an act to establish a fund to compensate unjustly incarcerated persons. The bill's, I'm sorry, Representative Libby.
Thank you, Mr. Chair. I just wanted to speak to Representative Thorne's point real quick. It's my understanding, because I have the same issue when I am at home on a different device. I can't see the hands raised. So if there's no one that says the outcome, and the folks on YouTube have the same issue. They can't see the raised hands. So just for transparency's sake, it would be nice to have at least afterwards an announcement of the numbers for the vote consistently. And for transparency's sake, as far as those watching from home, I think that's the point for consideration of doing a roll call versus a raised hand. Or doing a physically raised hand so that everyone could see that.
Thank you, Representative Libby. There were 11 votes in the affirmative, no votes in the negative. I thought I said it was unanimous, but I should be more clear, and I need to remember that the folks on YouTube are not aware, because I've watched some on YouTube. So thank you for pointing that out. Greatly appreciate it. The next and final work set, well, not the final one now, but the next work session is LD 478. Again, an act to establish a fund to compensate unjustly incarcerated persons. Bill sponsors our colleague, Representative Evangelos. I will turn it over to Peggy for her bill analysis.
Okay, thank you. This is LD 478. An act to establish a fund to compensate unjustly incarcerated persons. This is actually your second work session on it. You tabled it last time. There is a fund existing in statute now to compensate unjustly incarcerated or wrongfully convicted people, but you can only get compensated from that fund right now if you have a pardon from the governor that indicates that you were innocent. And we know that pardons have not been issued very frequently. So it's a very difficult process. This would establish a new process that is actually very similar to the processes in many states. It requires the person to either if they have a pardon, that's great, but if their conviction was reversed or vacated, if they had a new trial, they were found not guilty, or there was no subsequent prosecution after the vacation or the reversal, and if they are eligible because they meet those requirements, and they also did not participate in any way, like suborning perjury to get themselves convicted in the first place, then they're eligible, and they can prove they can file to have the district court review their case, and the district court then determines their eligibility. And what the claimant has to prove is by a preponderance of the evidence that they had the conviction, they were imprisoned, and then the conviction was reversed or vacated, and just what we talked about being eligible, it was either dismissed or on retrial the person was found not guilty. And the person has to prove by a preponderance of the evidence that they did not commit the crime for which they were convicted. Plus, they were not an accessory or an accomplice to that. to the crime that was the basis of the conviction. And so if they can prove those three things by a preponderance of the evidence, then the court determines that they are eligible and determines the amount of compensation, and the compensation is established on a per year basis that they've been imprisoned, or a per year basis that they've been on the sex offender registry. It does allow it gives notice to the person has to file within 2 years after the dismissal of the criminal charges or the finding of not guilty. And the person filing the claim, so the claimant has to serve a copy of the claim on the Attorney General. So the Attorney General can be heard in the district court proceeding. And the claimant can request a jury trial, and that's actually possible in other cases as well. Page 3 of the bill is mostly about the compensation and how it's paid. I think the last piece we were talking about a little bit was the certificate of innocence and expungement. Some states do have a certificate of innocence, some don't even go through that process. And some states automatically require the criminal records to be expunged because we don't have an expungement process in the state. Maybe you would turn that into a sealing process.
Thank you very much, Peggy, for your analysis. And we are joined by the bill sponsor, Representative Angelos. Do you have anything to add to the report from Ms. Reich?
Thank you, Mr. Chair. I'll be brief. We've been over this bill for a long time now, previous session for 2 years and now this year. I sent the committee members a newspaper article from a very recent case where a gentleman spent 44 years in prison and was offered the North Carolina limit of $750,000. So the idea that these injustices aren't going on obviously isn't supported by the evidence. These things are going on all over the country. The only thing I wanted to add, I see that the Administrative Office of the Courts has weighed in. And this seems to be a continuing issue where they're raising these, attempting to raise questions around the constitutionality of several of the bills I've sponsored. And this one, they're citing the unanswered question is whether the Maine Constitution would prohibit the court from issuing a certificate. See Article 5, Part 1, Section 11. That's the governor's authority. I want to make it clear that this bill requires that a court, the judicial branch, which as far as my memory is served, is a separate and equal branch of our government. This bill requires that a court has reversed and vacated the conviction. So the separate branch of government has acted. So there is no constitutional problem with this bill. Other than that, I'm not going to go round and round on it anymore. I've had my say previously. It's not going to apply to a lot of cases as the report from the court came in. And it's possible if the post-conviction bill I submitted makes it through, perhaps we'll allow a few of the innocent people who are in prison a chance for their freedom, which they're denied now because of the 1-year limitation on the introduction of evidence. And then if they're exonerated, they would qualify for this process. So with that, I'll make a motion not to pass and throw the debate open.
Before you get to that point, there is Senator Keim still with us? I know that she had raised a series of questions with the judicial branch, and I didn't know how she wanted to handle those. Senator Keim?
Thank you. Yes, can you hear me okay?
Yes.
Okay, first a question for Representative Evangelos, if I could. I noticed, and correct me if I'm wrong, I'm looking through what we considered last session, and I don't believe there was in last session's bill anything to do with having to have a certificate of innocence. Am I correct in that? And if I am, could you explain to me why you changed that?
I didn't make any changes to the bill. It's word for word what was reported out of the committee. I didn't change anything.
Okay, thank you. And I don't know if everyone in the committee did see, I did pose several questions to the judicial branch about the bill, and I don't know if everyone in the committee saw their response, but I think it would be helpful for Peggy to go over that.
We have Ms. Finn in the attendee room. Would you want to pose that question to Ms. Finn?
Yes, that'd be good. Thank you.
Thank you. If I could have Ms. Finn moved over. Welcome to your daily visit to the Judiciary Committee as we're trying to break for lunch. It seems to be the spot that you're often put in. I know you were posed 3 questions from Senator Keim. I don't know if you want to address those before we proceed to a motion on this bill.
Well, I think the memo that I submitted, and I apologize that it was so late. It took a while actually the part that took a while was the key looking at the actual cases and trying to determine how many people might be eligible based on the current situation. So that information is what took the longest. I think it speaks for itself. We did not weigh in on this originally. We just responded to Senator Keim's questions. You know, the answer really is how many we could determine was up to 11. And without looking, you know, further into the cases, it could be fewer than that. But that was the number, and that's since 1999. So that's, you know, 22 years, quite a period of time. Before that, it would be difficult. And I think in terms of establishing innocence, it's, you know, the same way as it would be in a trial. Someone would have to present evidence and meet the preponderance burden. There are different ways they could do that with forensic evidence as one example, DNA. I think that's probably what that would be, or a confession that someone else made showing that the, you know, defendant did not commit the crime. So, and there was also a question about assigned counsel, which would not be applicable here, given that it's a civil proceeding. So I think that summarizes the memo.
Thank you very much, Ms. Finn. Is that satisfactory to you, Senator Keim?
It is. Could you just discuss further the certificate of innocence and whether and how is the decision made? And Representative Evangelist says it wouldn't at all go against the Constitution, and yet here.
Senator Keim, if you could deactivate your video, your audio is breaking up again.
Thank you. Is this better?
It is much better. Thank you.
Okay. Yeah, just a question about their certificate of innocence versus a pardon from the governor and whether or not that's unconstitutional. I don't understand how, so Representative Evangelist says it is not, and then the court is saying that it probably is. How do we actually, how is that determination made?
Well, I would say that we're not saying that it probably is. The question is open. It hasn't ever been determined by a court. So I that would have to happen at some point in the future. We're not, it's an open question. So it's unclear at this point. I can't say that it's constitutional or not. And the memo does point out that there are some states who do issue these certificates. What we don't know is what kind of provisions are in their constitutions in terms of the commutation power. So that's an open question. I guess I can't give you more than that.
Thank you, Ms. Finn. And Representative Evangelos, did you have a motion that you wanted to put forth?
I do, but I want to contest the last point. The judicial branch is a co-equal branch of government. If a court comes down with a ruling that someone is exonerated, could somebody explain to me how that violates the governor's pardon power?
I don't think we have somebody here to answer that question. Ms. Finnis said that in her view, it's an open question, but that does not prevent you from making your motion to move this bill forward.
Well, it's not an open question. The judicial branch is a co-equal branch of government, and
No, that is not an open question. I'm just trying to help you move your bill
I
forward.
attempted to make a motion. I'll make it now. Ought to pass.
Thank you. We have a motion ought to pass from Representative Evangelos. Do I have a second? Representative Babich, is your hand up for a second?
It's up for a question.
A question to?
Ms. Finn, actually.
Okay. I must have missed that hand before. I will get back to your motion after a question to Ms. Finn. Representative Babich.
Oh, right now? Yes,
Right
sir.
now.
Okay, Ms. Finn, I wanted to ask if the burden of proof to go forward with the certificate being a preponderance of evidence. Could you respond to that? Are you familiar with any other states, or give me a personal reaction to the burden of proof?
Oh, I couldn't react, personally on that. And I have not reviewed the statutes of other states, so I do not know what their burdens are.
Okay, that does answer that. Thank you.
Senator Keim, I see your hand back up. Is that residual or?
Before we vote, I would like to have a corner caucus.
But we don't have a motion yet, so why don't we wait till we get to that point, and then we'll have the corner caucus. Representative Evangelos has made a motion ought to pass. Representative Sheehan, is that a second? Okay, we have a motion and a second ought to pass. How long will you need for your corner caucus, Senator Keim?
5 minutes.
Okay, we will see everyone back at 12:25 when we will vote on the motion that has been seconded. Thank you. And I will turn off my camera so no one has to see the top of my head. And I would recommend that others turn their cameras off as well. 12:25. Okay, as committee members return, if you could activate your video so I can see that we are back, and I welcome Representative Hagan.
Nice to
As
see you.
soon as we start up again, I'll have you introduce yourself to all of those assembled.
Thank you.
And it looks like, I'm just going to check. I don't see Representative Newell back, but we do have a critical mass, and I know that we promised to get started up again at 12:25, so we're a couple of minutes late. We have a motion by Representative Evangelos, ought to pass, seconded by Representative Sheehan. Is there any discussion amongst committee members? If so, please raise your electronic hand. And Representative Evangelos, I'm assuming that's up from before, or do you have something to add at this point?
No, it's something new. Senator Keim, are you with us?
Yes, I am.
I just dug the old bill out from my files, and you are correct. The revisor's office must have added a triggering clause to set this process in motion regarding 22-109. It's not something I asked for, but apparently they felt that in addition to the process of exoneration, there needed to be something to trigger the person going to court. So you are correct. There was a slight change to the bill. I just picked up on it now. I didn't want to provide you inaccurate information. Sorry about that.
Thank you.
You're welcome.
And is that something that you wanted to leave in the bill, Representative Evangelos?
Yes, I'm happy with the way the bill was drafted. I think they just felt that there needed to be some kind of a triggering process to allow the person to pursue the claim. The most important part of the bill, folks, is the fact that before this process even gets kicked off, a court in our state has made a finding of an exoneration and/or innocence. That's a predicate for anything else that goes on with this bill, similar to the story I just sent you, where a fellow served 44 years and then the courts found that the evidence against him wasn't credible. So that's the most important piece of this, and that's also protects the constitutionality of the bill, because the judicial branch is the one that weighs in and determines the outcome. That's all I have to say.
Thank you, Representative Evangelos. Is there a discussion from other committee members? Seeing no additional hands, I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Mr. Chair, I have 7 members voting in the affirmative, 5 members voting in the negative, and 2 members are absent.
Thank you very much, Committee Clerk. Excuse me, Panette. For those who voted in the negative, Senator Keim, what is your report?
We would like to vote on to pass as amended, and we would go with the minority report from last session, which had 50,000 a year and a 500,000 cap.
Thank you, Senator Keim. And that's all five who voted in the negative are ought to pass as amended?
Yes.
Thank you very much. And with that, I thank the bill's sponsor for bringing this forward. Thank the committee for their thoughtful deliberation, and will now, having the motion ought to pass having prevailed, I will close the work session on LD 478. And that brings us, did I miss any? Okay. That brings us to our next and final work session of the morning. And this is the one that we tabled recently. So do I need a motion to take it off the table, Peggy, or can we just begin the work session? I'll take that as we can just begin the work session. Thank you. We have LD 681 again, which is an act. I'm sorry, an act clarifying the removal process of individuals from certain facilities not governed by Title 14 of the Maine Revised Statutes. And I understand the bill's sponsor is here with an amendment. So I will not ask Peggy to do her thorough bill analysis, and welcome Senator Libby to the Judiciary Committee. Nice to see you again. If you could speak when you are comfortable and present the amendment that you wish the committee to consider.
Thank you, Representative Harnett and members of the committee. I emailed this amendment to the committee yesterday at about 2:20. So you'll have that in your inbox. The summary.
Peggy has outlined it. I should have told you, Senator Libby. Peggy outlined it before we found out you were going to be delayed. So.
Okay. I'm sorry, I was at HHS on another work session. So Peggy, you went through the amendment?
Just very briefly, we went over the membership a little bit and the duties.
Okay. I guess that really that's the substance of what I was hoping to talk with you about.
Okay. Thank you very much. Are there questions, excuse me, for the sponsor? And I see Senator Keim with a question.
Thank you. I don't actually have a question. I would like to make a motion on pass as.
Okay. Again, we're going to have to ask you to shut off your video because you're breaking up. I think you wanted to make a motion ought to pass as amended. I got that much out of it. Did you get that, Peggy?
Yes.
Okay, we have a motion from Senator Keim ought to pass as amended. Do I have a second? Representative Newell seconds the motion. Ought to pass as amended. Are there questions from committee members or discussion before we proceed to a vote? Seeing none, I would, Senator Carney.
I just wanted to express thanks to Senator Libby for all the work he's done on this issue and for continuing to bring his concerns forward to our committee.
Thank you, Senator Carney, and the committee echoes that sentiment. Thank you, Senator Libby. Seeing no additional questions or comments, I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator.
Somebody has a microphone that needs to be muted.
I'm going to mute everybody.
Yes.
Senator Carney.
Yes.
Thank you. Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Galgay Reckett. Representative Galgay Reckett is absent. Mr. Chair, I'm happy to say 12 members of the committee are voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much, Committee Clerk Panett. What a nice way to finish our morning, which is now our afternoon. Again, thank you to the bill's sponsor, Senator Libby, for his work throughout this, and we will probably see him again moving forward in our short session. So with that, I will close the public hearing, the work session on LD 478. We have a series of public hearings scheduled at 1 o'clock. I need to give committee members a break and also our staff. So I would ask us all to return at 1:15 so that we can begin our work sessions at that time. And unless anybody has any questions or something else to add, I would remind people to shut off your video, mute your mic, and we will see us all together again at 1:15. Thank you very much.
Thanks.
You're looking for me?
I'm looking for the bill sponsor on our first bill. Is that more?
He signed up. She's on the, I think she's on the bottom.
Okay,
You don't see her, is she in the attendee space? I think she's on the list.
on the list, but I don't see her here. Oh, yeah, she is. Okay,
There
why
she is.
why don't you just move her
Move
in?
her in, okay.
Good afternoon, committee members. As we get back from our break, if you could please activate your video so I know that you're here. And we can begin our series of public hearings. Yes,
Is it's my understanding that Senator Moore is going first? Is that your understanding as well?
that is correct. Her bill is up first and she is in the attendee space. And I just asked Soupy to move her over, so
Great. She had reached out to me. Thank you.
you're very welcome. Any idea when you'll be leaving us?
Yes, probably a little bit after 2, and I'm here until then. Let me
Okay.
know if you'd like me to do anything.
We're good. We are good. Hello, Senator Moore.
Good afternoon. How are you all today?
We're doing great.
Good.
You know, dozen work sessions, 6 public hearings, just a light day.
I can relate to that. I know we've got, I think, 9 or 10 in HHS, and we're only in number 4. So it's still going to be a long day today for sure.
Yeah. That's why we get paid so much money, Senator.
Yeah, right.
I'm going to give committee members just a few more minutes to get back from our break, but we'll start up no later than 1:20.
That'll be great. Awesome.
So now everybody needs to be in 3 places at one time.
I know it. You know, we used to complain about that at the State House. Now it's back and forth between Zoom meetings. It's terrible.
You know, you don't get as many steps in walking from your
I
phone to the
don't. I
computer.
don't. I don't get my 10,000 steps anymore. That's for sure.
Okay. Committee members, again, if you could activate your cameras so I know that you are here as we begin our afternoon's set of public hearings. Let's see, 1, 2, 3, 4. have 6 members, but we did have a quorum established this morning. I'd like a little more critical mass. And Peggy, are you with us?
I am, but you can't count me.
I know we can't. Do we need to reestablish the quorum for the work session?
I think the agreement was that once you establish a quorum in the beginning, if you were just continuing your meeting, that you were okay.
Okay,
and
thank you.
And now that I'm on camera, I'm also going to tell you that I just emailed you a proposed amendment from Representative Talbot Ross for her bill LD 1617, and I will be uploading it into the portal.
Well,
more to come.
Thank you. Thank you very much. I don't know how I'm going to get to look at that before we hear from Representative Talbot Ross.
I will be able to share it if she would like, if you want me to.
1, 2, 3, 4. Okay, we are going to start up. I'd like to try to stay as timely as possible, although time is a very fluid concept at this place. And we will begin our afternoon of public hearings in the Joint Standing Committee on the Judiciary. And the first bill that we have being presented to us today is LD 1577, an act to require police to enforce court-ordered child custody agreements. And the bill will be presented by Senator Moore. Senator Moore, welcome to the Judiciary Committee, and please begin your testimony as soon as you're comfortable.
I will do that. Thank you very much. And I appreciate you allowing us to go first as well. So this is awesome. Good afternoon, Senator Carney, Representative Harnett, and distinguished members of the Judiciary Joint Standing Committee. My name is Mary Ann Moore, and I proudly represent Senate District 6, which includes all of Washington County, along with Winter Harbor, Goldsboro, and Sullivan in Hancock County as well. I am here today to introduce LD 1577, an act to require police to enforce court-ordered child custody agreements. Last summer, one of my constituents, Les Cook, contacted me requesting I put in this bill because of his inability to see his 4-year-old son. He had reached out to local law enforcement personnel asking for assistance in the enforcement of his custodial visitation order without any success. As he explained to me, in the state of Maine, if a parent violates a court-ordered custody agreement, the police will not get involved. This bill would simply add an additional subsection under the Parental Rights and Responsibilities Statute stating enforcement by law enforcement would be the section number 15. Upon request of a parent, a law enforcement agency shall enforce an order granted under subsection 2, paragraph D, subparagraph 1. Mr. Cook will be providing testimony today, and I believe he is in the attendees list, and is sharing his story as an example of why we need legislation such as this. Thank you for your consideration of this very important bill.
Thank you very much, Senator Moore, for presenting this bill to us this afternoon. We appreciate you bringing it forward. Are there questions from committee members for the bill sponsor, Senator Moore? Representative Moriarty.
Thank you, Mr. Chair. Senator Moore, I'm just a bit confused because late yesterday afternoon, we had an email from our analyst enclosing an amendment which was to take the place of the bill. And it bears no relationship to your bill. It creates a working group to study various child custody issues. Senator, whether you or Peggy can clarify this, I'm confused.
Well, I was not even aware of this amendment until I was actually double checking to make sure my testimony was uploaded. And that's when I saw that it was on the digital file. So I actually downloaded a copy of it myself. I'm totally unaware of what this amendment is and what it's doing. So it did not originate from me.
Okay.
The amendment comes, Representative Moriarty, the amendment comes from somebody who's going to be testifying later. It is not a sponsor's amendment.
Okay.
As far as I understand.
Okay. All right. That's my only question. Thank you.
Thank you. Are there additional questions for the bill sponsor, Senator Moore? Seeing none, nice to see you again, Senator Moore. You are welcome to stay as a panelist for the rest of the hearing, but I imagine you may have other places you need to go as well. So, but
thank you, and I will stay on to hear Les Cook's testimony, give him a little bit of support. If I could remain in the panelist until he finishes his testimony, I would appreciate that.
Absolutely, you can remain as long as you like as a panelist. And before we begin to hear from members of the public, I'll remind people that we will take testimony by those in support of the bill first, followed by those in opposition, and then those neither for nor against. And I also will remind people that we have a 3-minute clock for everybody other than the bill sponsor. When there are 20 seconds left, I will hold up this yellow card, and when the time has expired, you will see a red folder. So with that, I would welcome Les Cook to the Judiciary Committee. And Mr. Cook, whenever you are comfortable, please feel free to unmute your microphone, activate your video, and begin your testimony. Mr. Cook, I need you to unmute your microphone.
Okay.
You've done that, and now activate your video.
There you go. Great.
Thank you, sir. And as soon as you're comfortable, begin your 3 minutes of testimony.
Okay, first I would like to apologize. I cannot read the testimony that I wrote down and use the phone at the same time. I was wondering if Mary Ann Moore could read mine, or I would just say what I can say out of memory.
We'd much prefer to hear the testimony from the member of the public.
Okay.
I will just add that his testimony is online,
right,
so that you can always go back and refer to that if necessary.
I see it has been submitted.
But,
so
so
maybe.
go ahead and share your story, Les. Yes, please.
March of 2020, my son's mother refused visitation. I tried to see my son. Due to COVID, it took 2 months to get into court to see my son. When I got him back, he showed obvious signs of separation anxiety, outbursts that I hadn't seen before. But in just 6 weeks, it happened again because really the situation was not addressed in court. And the police not interfering, she feels very safe doing this action. So it happened again, but this time the court systems were extremely backed up due to COVID, and it took 6 months to get back into court. I didn't see my son from July 7th until December 28th. To great distress to my family, myself, my son. I've had law enforcement try to explain to me why they don't get involved, and they tell me the reason is that they are not qualified to make a judgment if the parent is safe or which parent is safe. But this has already been hashed out in court, the expense of thousands and thousands of dollars of both parties. And the decision has already been made by somebody who is qualified, the judge. And I'm just asking for it to be enforced. It makes no sense to me to have to spend thousands of dollars and go months and months without seeing a kid. That's distressing enough, but the child, the 3 or 4 or 5 year old child, is used to seeing the parent half the week and are exceptionally close, but they're damaged by it, and to who knows what extent. So that's basically all I have to say. My son's going to be going to therapy. My mother's had to go see a doctor. She's 86 years old. She had to go to doctor, be put on medication over this, and I'm going to therapy. And this all can be handled in a 15-minute phone call. I mean, that is basically all I have to say on the issue. What I wrote down is more in depth.
Thank you very much, Mr. Cook, and rest assured that the committee reviews all testimony that has been submitted online, and we appreciate you taking the time to bring your story in front of the committee this afternoon. And I will now ask if there are any questions from committee members for Mr. Cook regarding his testimony. And seeing none, again, thank you very much for sharing your story. And you will be moved back to the attendee room, but you're welcome to stay to watch as much of the hearing as you would like.
All right, thank you very much.
Thank you, sir. I would now ask if there are any persons in the attendee room who wish to testify in favor of LD 1577. If so, please raise your electronic hand. And seeing none, I will now ask if there are persons in the attendee room wishing to speak in opposition to LD 1577 to please raise your electronic hand. And I see that we have been joined by a frequent visitor, Major Brian Scott. Welcome back, Major Scott. And as soon as you are comfortable and ready to go, I will start the 3-minute clock when you begin speaking.
Very good. Thank you, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Major Brian Scott, and I'm representing the Maine State Police and the Department of Public Safety in opposition to LD 1577. The enforcement of civil custody orders does not seem like a good use of law enforcement resources when most agencies are already stretched thin and short-staffed. We at the State Police are bursting at the seams and already beyond our capacity. We do not have the staff to adequately meet the current law enforcement demands placed on our agency, and this would further exacerbate the problem. We also value our relationship with the public and are working hard to build trust. Injecting ourselves in what has historically been a non-law enforcement matter will only erode the gains we have made over the years. Children will be taught to fear the police, and we will be seen as the one taking them away from their parents. And at times, parents will resist, and we will have to use force, resulting in an arrest, and arresting parents in front of their children while they're screaming. This bill would not allow a law enforcement officer any discretion when it comes to the enforcement of a custody order from a court. What if there is an allegation of child abuse, but it has not yet been fully investigated? Would we be required to turn the child over to a potential abuser? We would be required, what if a parent decided to call us at 2 a.m. and complain to us that this was their weekend to have the child? Would we be expected to wake a child in the middle of the night and remove them from their home? We have seen many, many times where a vindictive parent places their wants above the needs of their children and tries to use law enforcement as a weapon to victimize the other parent. I fear a parent who has not been in the child's life for several years could have a custody order enforced for the only purpose of tormenting the other parent. That would just result in victimization of the children. For an example, a parent that has been absent for the last decade could show up unannounced and demand that law enforcement enforces the court order that was entered 10 years ago without considering the devastation of the children. Parents can and do petition the court when custody orders are not followed. Sanctions can be put in place by the courts to include being held in contempt for non-compliance. Law enforcement already removed children at the order of a court when the judge demands it. And law enforcement currently enforces any protection order and remove children from parents when court ordered to do so based on an allegation or a finding of abuse. However, broadening the scope of that responsibility to enforcement of all custody orders is not appropriate. For these reasons, I strongly urge the committee to vote ought not to pass on the bill. I thank you for your time, and I'm happy to try and answer any questions. And I do want to state that I feel horrible for Mr. Cook's position. It is a unique circumstance with COVID and the courts not being available to members of the public to be able to petition them. But I don't think it is an appropriate role for law enforcement, especially in the days where we have seen kind of a change or a shift in what the duties should be. We should be involved less in social services and more in law enforcement related matters. Thank you.
Thank you very much, Major Scott, and thank you for coming before the committee to present your testimony this afternoon. Are there questions from committee members for Major Scott? Seeing none, again, thank you very much for your time and testimony today. We always appreciate seeing you. Thank you.
Very welcome. Very welcome.
I would next call upon Francine Stark, who's signed up to testify in opposition to LD 1577. Ms. Stark, as soon as you are comfortable, begin speaking, and I will start the 3-minute clock. Welcome.
Thank you. Senator Carney, Representative Harnett, and distinguished members of the committee. I am here on behalf of the Maine Coalition to End Domestic Violence because Andrea Mancuso is having a well-deserved vacation. I'm here speaking in opposition to LD 1557 and ask you to support the alternative approach that has been offered for this important issue. LD 1577 highlights a real problem in Maine, the lack of a process to seek immediate intervention by our family courts in times of crisis or parental mischief. However, by the solution proposed in this bill would actually serve to put children at greater risk by eliminating the ability of a protective parent to appropriate withhold the child from court-ordered visitation, often at the suggestion of law enforcement, child protective services, or the protective parent's attorney, when a situation has developed after the issuance of a parental rights and responsibilities order that implicates the safety of a child in the other parent's care. In Maine, the only emergency order that an individual parent can get from a court that would supersede a family court's prior order is a protection from abuse order. There are many situations where the safety of a child would be compromised by turning that child over to the other parent, and yet the circumstance would not be appropriate for a protection from abuse order. These include, for example, abuse against a child who is too young to testify, reports by the child to the protective parent of a neglect by the other parent, suicidality of a parent, threats to remove the child from the state or the country, a parent's association with another person during visitation who poses a risk to the child. The list goes on. In these situations, a protective parent can file a motion to modify the parental rights and responsibilities order and eventually be heard by the family court, but those petitions take weeks to get even a first court date and take months to resolve. If this bill were passed, law enforcement would have no choice but to remove the child from the protective parent and turn the child over to the parent who is alleged to pose a risk to the child. For this reason, we urge you not to support it. What Maine needs is an emergency custody petitioning process. A majority of other states have processes in place whereby a parent can file an emergency petition with the court, alleging that the court needs to take immediate and temporary action concerning the custody of a child. Temporary orders are typically in place for 2 or 3 weeks until such time as the parties can appear in front of a judge to present their case for whether or not the emergency order should continue, pending the final resolution of any motion to modify the permanent parental rights and responsibilities orders. Such processes put the resolution of family conflict and legitimate concerns about a child's welfare in the forum where it belongs, the family court, and provide the courts with a mechanism to address these matters urgently. More than 10 years ago, the Abuse Commission provided the Maine legislature with a report that noted this was a critical gap in our family court system, and it's past time that we address this. We understand that the Maine Commission will be presenting an amendment to that end. Thank you. I'll take any questions.
Thank you very much, Ms. Stark, and I apologize. I was knocked off the hearing for a while and had to scramble to get back on. But appreciate your being here and testifying this afternoon. Are there questions from committee members for Ms. Stark? Seeing none, again, thank you very much for your time and testimony.
Thank you.
We look forward to seeing you perhaps at the work session when this bill moves along. I would next call upon Lucia Hunt. Ms. Hunt, welcome back to the Judiciary Committee. As soon as you feel comfortable, please begin your testimony and I will begin the 3-minute clock.
Thank you, and good afternoon, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. My name is Lucia Hunt, and I am the chair of the Maine Commission on Domestic and Sexual Abuse. I'm here today speaking on behalf of the Commission in opposition to LD 1577, an act to require police to enforce court-ordered child custody agreements. I am proposing an amendment that would address this issue through a careful study of what is the underlying problem in these types of situations, the lack of an emergency child custody system within the district court. I am sympathetic to Mr. Cook's situation, and I would also add that the pandemic has really highlighted the problems of not being able to access the courts to resolve custody disputes in a timely way. Commission members discussed this proposed legislation at our last meeting and are concerned that the proposal as written would have unintended consequences and decrease child safety. Similar to the concerns raised by Major Scott, the concerns were that this proposal would require law enforcement to enforce a child custody order, including visitation, without any discretion on the part of law enforcement to evaluate the safety of the situation, whether the order is current, or the circumstances surrounding the family. The district court is really the best place for families to resolve custody disputes, but there isn't a system within the district court for the court to respond to emergency situations outside of the protection from abuse process. Examples include when a parent is suicidal, when a parent's substance use or mental health impacts child safety, parents who are charged with crimes that are related to child safety, for example, possession of child pornography. Those cases come to the attention of the criminal justice system or the Department of Health and Human Services, but those systems are also unable to respond effectively and in the emergency system or in the emergency situations that families face in this gap in the system. They don't have the right tools to address some of the emergency situations for families. If there is a protected parent in the situation, that parent is tasked with protecting the child. But parents are faced with an impossible task because Maine's courts don't have a system in place for a protective parent to access an ex parte emergency custody order. Filing a family matter takes time, and you won't be able to have an immediate result. This often leads to the inappropriate use of the protection from abuse system, putting parents and judges in the untenable situation of trying to protect children, but not having the right process in which to do so. The amendment that I'm proposing on behalf of the Abuse Commission would replace the existing proposal with a resolve directing the Abuse Commission to convene a working group of stakeholders, including the judicial branch, crucially the judicial branch, to study this issue and develop a statutory framework for an emergency ex parte system for temporary custody orders in family matter cases. Although this gap has been highlighted for many years, including in reports to this committee, there's still significant questions about how such a process would fit into Maine's court system. And for that reason, we're proposing the resolve to create a working group to really look at this issue in some detail. Thank you, and I would be happy to answer any questions.
Thank you very much, Ms. Hunt. We appreciate your time and testimony today, and I will now turn to questions from committee members, beginning with co-chair Senator Carney.
Thank you very much, Representative Harnett. Is there, you've described an ex parte emergency child custody process. Do you know if such processes exist in other states? And if so, can you describe kind of the approach they're taking, please?
You know, I really appreciate that question because I think it's a very, very good one. I know that other states do have processes, but their court systems are set up differently, particularly in the family matter divisions. So that's actually why, instead of proposing some legislation that would create such a process, I thought it was better to actually have some time to look at what other states are doing, to do a review of what those processes look like, and figure out how that type of a system might fit within Maine's existing framework, both the statute and rules, and really the court process itself. And so that's the reason for not proposing such a system at this point in time, but really asking for the opportunity to look at what other states are doing, talk to the people in Maine that this would impact, and come up with a proposal where we might be able to come back and say, here's how it would work in Maine, and having looked at not only other states, but our own systems as well.
Thank you very much. And I think you just referred to talking to people who are impacted. Would that include Mr. Cook potentially?
I would certainly be happy to speak with Mr. Cook, and my written testimony does have my contact information. You know, I think the pandemic has affected so many of these systems, and certainly from my perspective, child custody is one of those areas where it's highlighted some gaps that we already knew existed, but sort of exacerbated them in other ways.
Thank you.
Thank you, Senator Carney, and thank you for your responses, Ms. Hunt. Representative Moriarty.
Thank you, Mr. Chair. Ms. Hunt, you heard Mr. Cook describe a situation in which a former spouse simply refused to comply with an existing order of parental rights and responsibilities. At the risk of being unfair to you, would that constitute an emergency within the meaning of the amendment you propose?
You know, that's a really interesting question. I think the existing process for contempt might be the more appropriate system for the problem that Mr. Cook specifically references. But I do think that what the proposed language of this bill highlights, and what the Abuse Commission, was struck by with the proposal of the solution of using law enforcement to enforce child custody orders, went back to sort of this underlying gap within the system that I have to say is the subject of much discussion, and has been for a long time. So I don't know whether this system would be one that would be accessible to someone whose child has been withheld. But I do think that it emphasizes sort of the problem of not being able to access the courts in a timely way absent filing a protection order. And that's where we see litigants going when there's a problem, and they need the court to address it immediately. And the system just isn't the right fit for a lot of situations.
I have one follow-up question, Mr. Chair, if I might.
Absolutely. Go ahead.
Ms. Hunt, your amendment begs the question, who would enforce an ex parte order?
That is also a really good question, and thank you for it. I think that when you have an existing order of the court, now that's a civil order, the enforcement would remain the same. So now if you have a protection order, it is enforced by law enforcement. If you have a civil order, it's not enforced by law enforcement. So I think really what we're talking about is the process of obtaining an order that's responsive to an emergency situation, but it wouldn't necessarily impact the enforcement of that order.
So this wouldn't offer Mr. Cook any relief then, really, would it?
No, I don't think that it would necessarily. I think the suggestion for this ex parte process, the creation of this ex parte process, is to address more the underlying concern about not being able to access the court quickly in an emergency situation, not necessarily the problem identified by Mr. Cook in his situation.
Sure. Okay, good. Thank you.
Thank you, Representative Moriarty, and thank you for your response, Ms. Hunt. Are there additional questions from committee members for Ms. Hunt? Seeing none, I do have one, Ms. Hunt. Have you shared the amendment with the bill sponsor?
I apologize. I have not. And I don't really have an excuse for that other than the timing of the way that these bills have been coming up in the last few weeks. And Senator Moore, my apologies for not having reached out about it in advance.
Safe to assume that will happen though, and you will be in discussions with the senator?
I would certainly be happy to.
Okay. Thank you very much for your time and testimony. Representative Moriarty, do you have an additional question?
Oh, no, I'm sorry. No.
Okay. It's okay. We all do it. Additional questions from committee members? Seeing none, again, thank you very much for your time and testimony. We look forward to hearing about progress you make when you share the proposed amendment with the bill sponsor. Thank you.
Thank you so much.
I will now turn to the attendee room to see if there are any persons in attendance who wish to testify in opposition to LD 1577. If so, please raise your electronic hand. And seeing none, I would ask if there are any persons in the attendee room who wish to testify neither for nor against LD 1577. If so, please raise your electronic hand. And again, seeing none, having heard from all those present wishing to provide testimony on LD 1577, I now close the public hearing on LD 1577, and we thank the bill sponsor for bringing the bill forward. Nice to see you again, Senator Moore.
Thank you. Nice seeing you all as well. Bye now.
Bye-bye. We will now move to our next public hearing, which is LD 1606, an act to expand tenant representation on boards and boards of directors of nonprofit housing organizations, presented by Representative Grochowski. If the bill sponsor could be moved over as a panelist. Welcome, Representative Grochowski. It's nice to see you again in front of the Judiciary Committee. Thank you for bringing this bill forward, and as soon as you are comfortable, please begin your testimony.
Thank you so much. Good to see you all as well. Good afternoon, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. I am Nicole Grochowski, and I represent the communities of Ellsworth and Trenton in the main house. I appreciate the opportunity to speak in support of LD 1606, an act to expand tenant representation on boards of directors of nonprofit housing organizations. The title pretty much sums it up, but I will elaborate a bit. Specifically, this bill requires a nonprofit corporation that provides dwelling units in a multi-unit residential building to include a current tenant on its board of directors. It does not apply to a nonprofit corporation that only provides emergency shelter or short-term transitional housing. Before I share a proposed amendment to this bill to accomplish its goal without overburdening boards with dozens of tenant representatives, I'd like to share why I have introduced this legislation. Last summer, I was contacted by the daughter of a constituent who was concerned about the living conditions her mother was subject to at a nonprofit housing facility in my district. She shared what were truly alarming results from air quality tests that the facility had commissioned. For what it's worth, I have a degree in chemistry, and when I reviewed the truly off the charts numbers for volatile organic compounds, known as VOCs in particular, I was horrified. The constituent felt very ill in certain areas of her apartment, but she was able to manage by having all of her windows open, which is an untenable solution the main winter ahead. The results indicated that immediate action was necessary, and yet the facility's management was in no hurry. Management claimed the complaints were exaggerated, and when I contacted a board member with whom I had a personal relationship, I was told the same thing. Meanwhile, because I had taken an interest in this constituent's living conditions, other residents came forward to discuss their own issues with mold and general disrepair. They told me that their concerns were disregarded by management. They felt that they had no access to the facilities board, whose source of information was solely the management. Good news here is that we were able to finally get relief after about 2 months of my own involvement by escalating the situation to the facility's main funding source, USDA's Regional Rural Development Program. Since the apartment has been partially renovated with certain materials removed, my constituent is feeling much better and made it through the winter with her windows closed. In my quest to resolve this problem, I had to research who had oversight of this facility as well as who provided its funding. Along the way, I learned that the unrelated Mount Desert Island and Ellsworth housing authorities have 5 authority boards, each with 7 commissioners, 2 of whom are tenant representatives. All tenant commissioner positions are filled. It struck me that tenant representation is a great model to improve communications between the tenants and the board, as well as keeping tenant experiences front and center in decision-making. I do not assert that one tenant representative would have the same lived experience as all other tenants, but I do believe that such a representative would be more approachable by other tenants with concerns than other board members might be. As the saying goes, nothing about us without us. Many of the housing facilities that this bill would affect already have tenant representation on their boards, but others do not. I was able to help one constituent, but in speaking with other legislators about how to approach this problem, I learned of similar issues around our state. In an effort to improve living conditions and communications in these types of facilities statewide, I have introduced this bill. Since this bill has been published, I've received some very helpful feedback and support of the general concept of the bill. To that end, I'd like to provide the following amendment language for your consideration to replace the current language, subject to editing by your capable analysts, of course, and your own views as well. And that language is as follows. A corporation organized under this title that has an ownership interest in any multifamily rental housing shall include on its board of directors at minimum one current tenant of such housing. If the corporation is unable to find a tenant to serve as director, it shall advertise the position to current tenants on an annual basis. The name and contact information of the tenant director shall be posted in a public location in each building for which the corporation has an interest. This section does not apply to a corporation that only provides emergency shelter or short-term transitional housing. And to clarify the reasons for the amendment, I would note that affordable housing in Maine is sometimes owned by a for-profit entity in order to receive tax credit financing, but associated with a nonprofit entity that has a board. Additionally, the nonprofit entity may have multiple buildings, and it was never my intention that each building have a tenant representative, as that could make for a very unwieldy board. However, all tenants should be made aware of who their tenant representative is, since that person may not live in their building or housing complex. This language also reflects that there may be no tenant with interest in serving on the board. I would note that new board members are generally approved by current board members, so I am not personally concerned that tenant representation would be disruptive to the board achieving its basic functions. Thank you all for listening attentively to my testimony in support of LD 1606 and my recommended amendments, and I would be happy to answer any questions.
Thank you very much, Representative Grochowski. Thank you for bringing this bill forward and serving your constituent. Are there questions from committee members for the bill sponsor, Representative Grochowski? Representative Thorne.
Thank you, Mr. Chair. Welcome, Representative Grochowski, to Judiciary Committee, and thank you for bringing this bill to us today. Couple things. You mentioned there shall be no tenant with interest on the board. Does that mean no tenant that has a share of ownership in the building?
That was definitely not my intention. I'm not sure which language you're referring to.
You had mentioned near the end of your testimony that there shall be no tenant with interest that will sit on the board.
No, I'm sorry if I was confusing in my language. That was not a statement that I made. The language that I read said that the corporation that has an ownership interest in the sort of housing facilities shall include on its board a tenant.
Okay.
So I think maybe the sentence just got sort of switched around. I think that was the only reference to interest
Okay.
in that case.
And a follow-up, if I may, Mr. Chair?
Yes, Representative.
Representative Grochowski, in the beginning of your testimony, you mentioned some chemical compounds. And I was just curious, if, in layman's terms, what that odor was, and if it had a source. Was it ever determined?
Volatile organic compounds can result in, can come from the breakdown or off-gassing of a number of synthetic materials. It could come from personal care products. In that particular situation, they removed the flooring in the bathroom as well as a vanity that was of a sort of compressed board that was deteriorating. Those items were never tested, but it did ameliorate the problem. So I think it would be fair to assess that that was at least part of the source. But there are other, nail polish, for instance, puts off volatile organic compounds, which is, I don't know when you were last got your nails done, but the facilities have a lot of proper ventilation to account for that. Same with flooring. that's put down. So they can be pretty widespread, but the levels were, I saw the results literally off the charts. It was very alarming to me. And
it was needless to say, it was building induced, is what you're saying.
It does appear to be the case, given that my constituent now feels better since those items were removed. So I didn't test it specifically, and the facility chose not to spend money to do a follow-up test, despite that I recommended that would be a valid endeavor, but that's their choice.
Thank you. That puts it in context. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions for the bill sponsor from committee members? Seeing none, again, Representative Grochowski, thank you very much for bringing the bill forward as the bill sponsor to stay as a panelist through the conclusion of the hearing. But we certainly understand if you have other places you need to be, as we so often find ourselves. But thank you for bringing the bill forward. And at this point, I do not see anybody who signed up to testify in support of LD 1606, but I will check the attendee room to see if there's any person who wishes to speak in support of LD 1606. If so, please raise your electronic hand. Seeing none, I do see that we had one person registered to testify in opposition to this LD, and that is Sharon Val. And I welcome Sharon Val to the Judiciary Committee. As soon as you are ready to speak, just remember we do run a 3-minute clock on everyone but the bill sponsor. I'll hold up a little yellow piece of paper when you have 20 seconds left, and then red when the time is up. And if those hints don't work, I'll let you know. So as soon as you feel comfortable, please begin your testimony.
Thank you. And I will talk as quickly as I can to be respectful of that 3-minute window. Thank you, Representative Harnett, and all members of the Judiciary Committee for hearing me today. Again, my name is Sharon Vale, and I'm speaking to you today as president of the Maine Real Estate Managers Association. Our organization represents over 80 professional affordable housing property management companies throughout the state of Maine, managing about 16,000 apartment homes. Our association is made up of both nonprofit and for-profit property management companies and owners, but we are all mission driven. We are all focused on an enhanced quality of life for our residents, and that also includes them having a voice. That being said, we are opposing this bill as it's written in its current form for a few reasons. One of this, I think the representative touched upon prior to the amendment. This would require a representation of all buildings, and some of our members have portfolios of more than 100 properties across the state of Maine. So that would be a challenge to effectively have a board of that size for any nonprofit organization. Also, being managers of affordable housing, we're aware that a lot of our community members work jobs. It's difficult to take time off to actively participate in board meetings. Some of our residents also have family responsibilities. And because of this, our members have found that it can be really difficult to recruit when a board spot is open. Also, because affordable housing is incredibly complex with different program requirements and regulations, one resident's perspective on the board would not necessarily meet another household's needs or raise the same questions. It would not represent the entire community as is intended with this bill. And some affordable housing communities in Maine are owned by nonprofit organizations headquartered outside of the state, and that would make board participation challenging. So while we're opposing this bill, we're not opposing the need for community members to have a formal or informal avenue to provide feedback. We polled our members, and here are some existing options for residents to effectively be heard. If management companies or boards ensure that every household has a copy of a grievance policy at move-in that includes staff names, positions, and contact information, so residents know how to share their concerns and they'll be heard. We offer annual resident satisfaction surveys that can be sent anonymously to the governing nonprofit, hosting community forums where staff or board are present to answer questions, basically generally assuring residents have contact information. Okay, I think my time's up. Thank you so much for hearing my feedback, and I'm happy to field any questions. Thank you.
Thank you very much, Ms. Vale, for your testimony. Are there committee members with questions for Ms. Vale? Representative Thorne.
Thank you, Mr. Chair. Ms. Vale, you mentioned that a lot of owners have multiple rental units and that it would be unfeasible to have one of each. And I don't know if the intent of this bill is to have a representative from each unit or just a singular tenant from a unit on the board of directors. Are you?
The way the bill is currently written, and I apologize, I did not get the amended version that Representative Grochowski referenced, but the way it's written now is it would be one tenant rep from every building. So some, say a management company like Avesta Housing manages 100 properties across the state. Each property could have multiple buildings. So logistically, that's where the challenge comes into play.
Thank you for clarifying that. Appreciate it. Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Ms. Vale. I was wondering if I could ask you to finish the suggestions you have that the boards might implement. I thought you had brought up some great ideas, and I'd like to hear the rest if you have more.
Yeah, absolutely. And I think I might have hit on all of them, although I hurried through them. So I'll just reiterate those and be happy to elaborate if necessary. So when a household or a resident moves in, if a copy of a grievance policy at move-in can be provided, usually it is, but if it's required that it's provided, that grievance policy gives every resident the name, position, and contact information of a person they can connect with. And that policy is approved, by the owner and by the property management company. So there's credibility there. And you could even consider maybe including board members on that grievance policy contact information. Another option is we offer annual resident satisfaction surveys. And those can be completed anonymously so residents can feel comfortable being honest about some concerns they may have. And that will also establish if there are patterns of concerns that the board of directors should focus on. Hosting property community meetings or forums where board of directors could be present to field questions is another option. And again, just generally ensuring residents have the contact information for staff for any concerns they might have, where the suggestions are the actual things that our members are doing now that we find very successful.
Thank you. Thank you very much.
Thank you, Representative Libby. Are there additional questions from Ms. Vale from committee members? Representative Newell.
Thank you, Mr. Chair. Good afternoon, Ms. Vale. Thank you for being here and providing your testimony. I wonder, you mentioned 80 professional management companies with a board of directors. Could you kind of clarify the makeup of those board of directors? Who might serve as a member of the board of directors? And how many of those 80 professional management companies actually have a board of directors?
That's a great question, and I'm going to answer it the best I can because I don't have exact feedback to give you. The simple answer is of the 80 property management companies, not all of them have board of directors. Some are large, CNC Realty out of Augusta, the Housing Foundation out of Bangor, Avesta Housing out of Portland, and they do have a formalized board of directors. Some are small. We have, Fort Fairfield Housing Authority, which is very small. And so I think not every management company or owner has a board of directors. And if so, the ones that have that, the makeup can vary. So Avesta Housing, for example, I believe has 12 board members, and they have 2 tenant representatives on those boards. That's kind of a good example for a property management owner of that size.
Mr. Chair, follow-up question?
Yes, Representative Newell.
Thank you, Ms. Vale, for that response. Might I just ask, you mentioned a particular management company did have tenant representation.
Yeah.
So how many would you say of the 80 professional management companies would have tenant representation?
Yeah, that's a great question. I'd be speculating, but I would say maybe.
Ms. Vale, we're having difficulty hearing you. You need to get closer to your mic.
Zoom, yeah. I hope this is better.
It is.
Representative Newell, I was saying I am speculating, and I apologize. I can follow up with the group with better stats, but I believe it's about 50% of our members have boards, and if they boards with tenant representatives. But all the different other mechanisms that I listed are pretty much options across the board for all management companies in one way or the other.
Thank you, Ms. Vale.
Thank you, Representative Newell. Representative Babbage.
Thank you, sir. Yes, I'm heard. Okay. Thank you, Mr. Chairman, and thank you, Ms. Vale, for your testimony. To follow up on your alternatives, that was great. I appreciate the suggestion for community forums and the resident satisfaction surveys. Regarding a grievance policy, do you know if that's in statute? Is that a requirement that property managers have a grievance policy with?
Perfect question. Yeah, if it is a requirement, I don't believe it's a statute. I believe it would be a requirement of a funding program such as HUD or rural development, or maybe even the main housing rental loan program, but I don't think it's a statute.
I have not yet gone to your website. Do you happen to have a model grievance policy available to your members?
I don't on my website, but I could get one pretty quickly. I could reach out to a handful of members, and I'm sure they'd be happy to provide a template.
That might be a good service for those that don't have it. Thank you.
It's a good idea.
Thank you, Representative Babbage. Are there additional questions for Ms. Vale? Representative Babbage, if you could put your electronic hand down. Thank you. Seeing no additional questions from committee members, Ms. Vale, thank you very much for taking the time out of your day to provide testimony and answer questions from the committee.
Thank you for having me.
Thank you. That exhausts my list of people that have registered online to testify, but I will go back to the attendee room and ask if there are any persons who wish to testify in opposition to LD 1606 to please raise your electronic hand. And seeing none, I would ask if there are any persons wishing to testify neither for nor against LD 1606 to please raise your electronic hand. And seeing none, I thank the bill sponsor for bringing the bill forward to the Judiciary Committee. And having heard testimony from all those present wishing to present testimony, I now declare the public hearing on LD 1606 closed. Thank you all. Our next public hearing is LD 1609, an act to stop social media censorship. The bill is presented by Representative Sampson. Representative Sampson, welcome back to the Judiciary Committee. It's good to see you again. Please begin your presentation as soon as you're comfortable.
Thank you, Representative Harnett. Nice to see you too. And greetings to the members of the Committee on the Judiciary. I am Heidi Sampson, representing the good people of House District 21. That's Alfred, Limerick, Shapley, Newfield, and Parsonsfield. I am pleased to introduce LD 1609, an act to stop social media censorship. This proposal to stop social media censorship act creates a private right of action that allows citizens of this state to bring against the major social media websites that have more than 75 million subscribers that were never affiliated with any religious or political group from their inception, that censored the users of religious and political reasons for religious and political reasons. To be specific, this act applies to the social media websites such as Facebook, Twitter, and YouTube. Currently, when a social media website censors a user for religious or political reasons, the victim can sue the social media website for an existing form of breach, bad faith, unfair dealing, unjust enrichment, and false advertising. The act gives teeth to an existing form of actionable conduct that makes litigation realistic. Leading up to the introduction of this bill, the problem has been that it has been difficult for victims of censorship or the courts to determine how to calculate damage when a social media website deletes a profile for arbitrary reasons. This act allows the victim to seek statutory damages of $75,000 on top of the other forms of damage. So there has been some guarantee of recovery, making it realistic that victims will hold the social media website accountable. This bill also allows the victim to seek attorney fees and costs. This will incentivize local lawyers to take on these cases. This bill will strengthen the bar and the law economy while deterring social media censorship by leveling the playing field. $75,000 is the jurisdictional minimum to get an injured party into federal district court under diversity jurisdiction. None of these social media websites engaged in censoring the public, none of them reside in Maine. Therefore, the matters would need to be litigated in federal court. It is my understanding that states have a paramount jurisdiction over contract law issues. When someone in Maine signs up to use a social media website, they enter into a contract. Therefore, Maine can set some parameters around those contracts and hold certain actors to high standards that have been prone to bad acts without accountability. When a citizen of our state is censored, the courts in this state could have paramount jurisdiction over the controversy under the long-arm statute. The free exercise clause of the First Amendment is the underlying federal constitutional legal basis for this bill. Therefore, we in the state of Maine are able to introduce policy language to treat major social media websites as we treat public utilities. However, to create a private right of action would likely be a better first step towards the solution of this problem. Basically, the major social media websites have knowingly created a digital public square. Maine has a compelling interest to ensure its citizens are permitted to speak their religious and political opinions in any form of quasi-public square. This act will better allow the citizens of Maine, regardless of political or religious persuasion, to share their views by holding major social media websites to higher standards of care through carving out a special cause of action. It is vital to mention the few exceptions and exemptions that go with this act. The social media website can censor certain speech such as pornography, accounts that are falsely impersonating, or speech that calls for immediate acts of violence. I thank you for your consideration and your attention.
Thank you very much, Representative Sampson, and thank you for bringing this bill forward to the Judiciary Committee. I will now turn it over to questions for committee members, beginning with Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Representative Sampson. I wonder if you could enlighten our committee. I personally know of dozens of people who were censored on Facebook over the last 6 months. Accounts locked down and they were not allowed to post or comment. And I wonder if that has been a common experience. Have you had any firsthand knowledge of similar experiences in your acquaintance?
Yeah, thank you for that question. And actually, that was one of the reasons why I wanted to bring this bill forward. And I actually have had numerous people reach out to me, and some of the most unsuspecting. I mean, in really in all cases, they were unsuspecting victims who weren't doing anything provocative. And I can think of, in particular, the one that stands out to me the most is this young mother. She maybe had a couple of hundred followers on her Facebook page. And really, she doesn't even know what the reason was. All of a sudden, her entire account was gone, just gone. And she was extremely upset because that meant all the pictures. She just had a baby. There were all these pictures of the baby and their wedding. And so all of those just disappeared overnight. And with who do you reach out to? Who do you ask the questions of? And what was the reason for it disappearing? And hers was probably the most outrageous because she's just a young girl, new mom, hardly anyone even on her Facebook page. It wasn't like there was this massive movement, nothing like that. And I've had numerous examples of people on so many different issues that just their Facebook page was completely shut down. As members of the legislature, I've been able to try and restate some of those through some of our contacts that we are privileged to as legislators, but not all of them were successful. And so it just seemed like such an egregious and really it's very unfair. It's unfair. It's not allowing, certain people are allowed to say whatever they want to say, and somebody else doesn't even know what they said and they get shut down. So it's not a level playing field by any stretch of the imagination. And it seems to be an increasing thing. We're seeing this increasingly, but this isn't just talking about big names. These are talking about everyday citizens, my constituents and friends around the state of Maine. And so hopefully that answers your question.
It does. If I could ask a quick follow-up, Mr. Chair?
Yes, you may, Representative Libby.
Do you believe, or does your constituent believe that the actions on the on the part of the social media platform went against her First Amendment rights?
Oh, without question. It shut it down completely without any warning. That's the other thing. No warning, no explanation. It was completely removed.
Thank you.
And there were other cases, but hers just seems so absolutely insane.
Thank you very much.
Thank you, Representative Libby, and thank you for your responses, Representative Sampson. Representative Moriarty.
Thank you, Mr. Chair. Good afternoon, Representative Sampson. Obviously, as we all know, every bill has a sponsor. And frequently this session, we've had public hearings and sponsors have come forward to present their bills, and yet at the same time have frankly acknowledged to us that they really are not acting on their own, but are acting on behalf of some other organization. It may be governmental, It may be private. It may be on behalf of a person or one thing or the other. And then they have deferred to that person, organization, or governmental entity to kind of carry the water, so to speak. So my question to you is, if you can answer for us, whether this bill has been presented on behalf of or at the request of some other organization or individual.
Well, that's an interesting question, and I'm happy to answer that. Because as I already said, this was an issue that I already had a problem with in my district and folks around the state who had reached out to me. And so I was looking for language that I could use to introduce. And so, yes, so there's a gentleman who is an attorney who has been litigating some of these cases on a federal level, who is prepared to speak to this bill. But to imply that I brought something forward because someone asked me, sir, you don't know me. So I have very clearly, I have asked to submit this bill. And this is something that I hold as very important and something that absolutely needs to be addressed.
Okay, well, that's fine. But as I said, many people have come forward and said, I've been asked by so-and-so to present this bill, myself included.
I can honestly say I was not asked. I asked myself.
That's the answer to the question. Thank you.
Thank you.
Thank you, Representative Moriarty. Thank you for your response. Representative Sampson, Representative Evangelos.
Thank you, Mr. Chair. Good afternoon, Representative Sampson. One of the concerns I have with the bill is, and I understand your concern and things of that nature, but the part about having the Attorney General be the lawyer for these people who feel they've been disaffected, don't you think that's sort of a dangerous precedent and slippery slope? It could be that the Attorney General's office is going to be getting awful busy.
Well, that's a possibility. But honestly, Representative Evangelos, you know as well as I know, once a bill is in the committee's hands, a committee can do what they choose to do with that bill. So it's a suggestion and worth considering. And so I'm not really sure how else to answer that, except what would you suggest? And you're on this committee.
Well, I mean, the other alternative in these sorts of cases is the people obtain legal counsel.
Well, like I said, as a member of the judiciary with this bill in your jurisdiction, you would have the liberty to amend the bill as you choose to do so.
Thank you.
Thank you, Representative Evangelos. Thank you, Representative Sampson. Representative Thorne.
Thank you, Mr. Chair. And to Representative Evangelos's point, I'm just reading through when it addresses in the bill the Attorney General. Line 27 on page 2. The Attorney General may bring, and then on page 3, line 13, a social media website user or the Attorney General may bring an action. I don't see anything that requires the Attorney General's involvement, just that it allows.
Correct. Correct.
Did I miss something in your statement?
It is, they may.
May. Okay, thank you.
Thank you, Representative Thorne. Representative Poirier.
Thank you, Mr. Chair, and welcome, Representative Sampson. Good to see you. My question is, in the crafting of this bill, did you look to other states and have other states in fact pass similar legislation?
Well, I know there's other states that have submitted similar language, and I'm not going to speak to that as much as the gentleman who is going to follow me can speak to that, because he's been working in those states.
Thank you.
Thank you, Representative Poirier. Are there additional questions for the bill sponsor, Representative Sampson? Seeing none, again, thank you very much for bringing the bill forward, and thank you for taking the time to testify before the committee today. As the bill sponsor, you are welcome to stay as a panelist for the remainder of the public hearing if you so choose.
I appreciate it. Thank you.
You're very welcome. I will next turn to persons who have registered to testify in support of LD 1609 and ask for Christopher Sevier to be moved into the room as a panelist. And I would remind people, as I will do all afternoon, other than the bill's sponsor, all persons testifying will be limited to a 3-minute time clock. With 20 seconds left, I will hold up a yellow Post-it and then put that down. And then at the end of 3 minutes, I will hold up a red folder that indicates that your time is up. So at this point, I would recognize Mr. Sevier. Mr. Sevier, welcome back to the Judiciary Committee. Whenever you are comfortable, please begin your 3-minute testimony.
Thank you, Mr. Chairman and Madam Chairman, distinguished members of the Judiciary Committee. I'm going to talk very quickly. Feel free to ask me any questions you want. Chris Sevier from De facto Attorneys General. There's 29 states moving on this. Three of the states, the prime sponsors are Democrats. This is a bill that's designed to protect your constituents. That's what this is about. I'm coming to you as an officer of the federal district court to say that the solution here does not need to be a federal one, doesn't need to be a judicial one. We need the state legislators to enact this bill in all the states because of this reason. This is a key point. The bill was written to fall within what's called the state law exemption of Section 230 of the Communications Decency Act. It's subsection E, subparagraph 3. So what does that mean? What is Section 230? It's a statute passed in the 1990s by the federal Congress that allows internet intermediaries to invoke a defense if they get sued for the acts of third parties. So that's still confusing. What does that mean? So the best way to understand it is through an example. If someone posts a defamatory comment on YouTube, the defamed individual can sue the person who defamed them. But if they named YouTube in that litigation, YouTube could invoke a Section 230 immunity defense and be dismissed from the case. So we think Section 230 is good law. However, what's been happening now to your constituents is that when they get censored, Democrat and Republican both, if they try to take recourse, the tech companies invoke Section 230 immunity defenses in litigation. This bill is written to fall within an exemption that was carved out by Congress that allows the states to pass the bill so that you can protect your constituents. And that's what this bill would allow. If you bring a lawsuit, an individual or the Attorney General brings a lawsuit pursuant to this statute, then when the tech companies invoke a Section 230 immunity defense, it will cut through it and it won't work. So that's why this bill is a bipartisan matter that we really need the states to provide a solution to. Okay, so that's point one. I got 3 other points. I'm going to try to get them in. Point 2 would be, what does this bill say? It says going forward in the state, if a social media website that has more than 75 million subscribers that was never affiliated with a religious or political party from their inception, if they contract with a constituent in your district and they turn around and censor them for their religious or political beliefs, you guys will be giving them power where they will be able to bring a lawsuit pursuant to the statute in civil court, where they can file in federal court or state court. They have choice of venue, where they can seek up to $75,000 in statutory damages, attorney's fees, costs, and other forms of equitable relief. And that is going to crush social media censorship. The contract law is a state law issue. When a member of your district signs up for Facebook, Twitter, YouTube, they're entering into a contract. You guys have jurisdiction to regulate here. It's an adhesion contract, but it's still a contract, so it gives you jurisdiction. But the courts look at mainly how they market themselves in terms of whether, enforceability. They're not going to really enforce the contract. They're going to look at how they market themselves. This is a key point. When a person in your district signs up for social media website and they get censored, that's an existing form of breach of contract, bad faith, unfair dealing, fraudulent inducement, false advertising. This is deceptive trade practice. This is deceptive trade practice. All this is what this is. And so those are not forms of First Amendment protected speech. They're not protected under the First Amendment. And I've got 2 other points, but Mr. Chairman, I might be out of time.
You are, sir.
Yes.
The 3 minutes has expired, and I forgot to mention that all persons testifying should open by letting the committee know their town of residence.
Yes, sir. Well, I'm working in 37 states. I'm in Hollywood, California today, but when I'm in Maine and I'm working with different assets there, whether we're fighting human trafficking, I'm working out of Augusta.
Your town of residence, where you reside.
New York City is where I live most of the time when I'm not. Yeah.
Thank you, sir. I will now open it up to questions from committee members. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Mr. Sevier. This is a new area for me, so I would appreciate hearing your final 2 points, if you could, please.
Can I make before responding to that, I'd like to make a request to committee members. We have a 3-minute clock for a reason. We have 170 bills that we are working. We give each person 3 minutes to provide testimony other than the sponsor, and we then open it for clarifying questions. If the question is, could you please repeat your testimony? We conclude your testimony. We no longer have a 3-minute clock. So I would ask that you pose it as a question, Representative Libby.
I certainly can do that. I can get very specific. So my question at the moment is, what is the underlying constitutional legal basis for this bill?
So this was the point I was going to try to address. So basically, the opponents of this bill are going to say this bill violates the First Amendment in some general, vague way, but they won't explain how. And they're going to act in their own interest, and they're not going to care about your constituents. Okay. The First Amendment of the United States Constitution, as well as the Maine Constitution, does not apply to private actors. It applies to the government. It limits the government from engaging in action that encroaches on free speech. But bad faith, unfair dealing, false advertising, deceptive trade practice, those are not protected forms of speech. So the First Amendment does not protect them. The First Amendment, while it's a restraint on governments, restraint on the state legislature, it's also like a trampoline. It's a catalyst where it gives you the power to act through it so that you can protect your constituents from consumer protection violations. This is a very straightforward consumer protection bill that Representative Heidi Sampson is the prime sponsor of, that she's put together. And so again, the First Amendment is the underlying federal constitutional legal basis. Any argument floated by opposition is going to manipulate that, and they're going to distort that. And there's no way to get around the fact that this bill is written to fall within the state law exemption under Section 230 of the Communications Decency Act. So it's not preempted by the federal doctrine of preemption, nor is it preempted by the First Amendment. In fact, the First Amendment is the catalyst by which you guys can act to protect your constituents on a bipartisan matter. This is above politics. This is a very serious problem that's hurting constituents all around Maine.
Thank you.
Follow up, if I may, Mr. Chair?
Yes.
Yes, you may, Representative Libby.
Thank you. So I have heard it suggested that if folks don't like the censorship, they can just get out and do their own thing. So can you explain, I know that there was a lot of brouhaha around Parler recently. So can you please explain why that's not really a tenable option?
Yes, Representative. There's different forms of objections to any bill. One would be, some sides say the First Amendment, and I'll explain that. The other side is, well, if you don't like Facebook or Twitter and you live in Maine, why don't you go out and form your own Facebook, Twitter, or YouTube? And the reason why that proposed solution is untenable as a matter of law is because Facebook, Twitter, and YouTube have reached what's called critical mass. They have billions of subscribers. Hundreds of thousands of people in Maine or have a user profile on these accounts. And, what they've done is they've accomplished that through fraud. They've promised your constituents that they can sign up, they can post their pictures, they can express themselves, only to then turn around and censor them if the speech offends the delicate sensibilities of the employees who just happen to work at those social media websites for that day. So it's not, from a legal perspective, the idea of, well, you can just go out and form your own thing and allow us to get away with false advertising and fraudulent inducement. That's an untenable legal solution. Again, I'm going to keep saying this, and that is the solution. There's not many solutions to this. We can't repeal Section 230. That would have bad secondary effects. The courts have been looking for a solution, and it is our impression as federal litigators that the courts are suggesting and indicating and tipping their hat to say they need the state legislatures, whether they're blue or red, to enact this statute. It falls within the state law exemption. The bill is designed to parallel the spirit of Section 230. It doesn't conflict with it. It parallels it. The Communications Decency Act was designed to promote decent speech. It was designed to fight pornography, really. It was never designed to be used as an excuse to enable deceptive trade practices, which are practices that are injurious to your constituents.
And I do have one more follow-up, Mr. Chair. I'm happy to defer if anyone else would like to ask any questions, and you can come back to me.
I will do that, Representative Libby. Representative Newell.
Thank you, Mr. Chair. I would just ask, Mr. Chair, if we can move on with the next individual here to testify.
Thank you, Representative Newell. I will allow one follow-up question from Representative Libby, a clarifying question about the testimony.
Yes, thank you. You said something briefly, Mr. Sevier, about exemptions, and you specifically mentioned pornography. So would this bill still allow for the social media platforms to not allow certain actions if they are not legal?
Yeah, absolutely. So, in working with Democrats like Senator Gabbard, Tulsi Gabbard's father, who's the prime sponsor of this in Hawaii, or Representative Wilkinson from Rhode Island, who's a prime sponsor, or the sponsors from New York, or Democrat sponsors out of the country, we have sat down with tech together in a bipartisan, mature manner to determine what should those exemptions and exceptions.
Mr. Sevier, I believe you answered the question when you said yes.
I did not answer the question, sir.
She asked a yes or no question, and you answered it yes.
I don't even, Mr. Chairman, I mean, if you want me to help you, I'm glad to help you. But if you,
I understand that, sir, but we have a slew of bills in front of us today. She asked a yes or no question. You answered it yes. Representative Libby.
I would like to make the point of order that this witness is for the second time on a second bill being treated in a hostile manner that I have not seen on any other bills. He is not being antagonistic or inappropriate, and I would like to see him be able to give full answers. I have not seen this on a single Democrat bill, and I would like Representative Sampson's bill to have the full hearing that it deserves, and that means having all of our questions answered.
But
Thank you.
You asked a yes or no question, and he answered yes, and then went on into a speech. We're not here for speeches. We're here to ask clarifying questions to persons presenting testimony.
Well,
if you have a question to ask, you may ask the question, but we cannot have the questions answered with speeches.
I appreciate that, Mr. Chair, and I will be sure in the future to call a point of order anytime someone expounds beyond a simple yes or no for a yes or no question. Thank you.
Thank you. Are there additional questions from committee members? Seeing none, thank you very much for your testimony today, Mr. Sevier. We appreciate you taking time out of your day.
Yes, sir.
Looking at persons who have registered to testify, I do not see anyone else registered to testify in support of LD 1609, but I will check the attendee room to make sure that make sure there is not somebody who wants to testify in favor who did not have the opportunity to register. If you want to testify in favor of LD 1609, please raise your electronic hand. Seeing none, I will now turn to those testifying in opposition to LD 1609 and call upon Carl, I hope I'm saying your name right, Sabo.
Spot on, Mr. Chairman. Thank you very much.
And I would just remind you, sir, as I remind all witnesses, we have a 3-minute clock, and please start by letting us know your residence. Thank you.
Will do. My name is Carl Szabo. I'm Vice President and General Counsel of NetChoice. I'm also adjunct professor at the George Mason Law School. My residence is Rockville, Maryland. Thank you for the time this afternoon. I've been addressing these issues across the country. I myself am a conservative, but I am opposed to LD 1609. Why? Because it violates the First Amendment and conservative principles that private businesses should be able to do what they want. Now, one of the things that's important to note is there's a lot of lawful but awful speech out there that would be allowed under this legislation. Political speech does include terrorist recruitment speech. It's their political views that America should be destroyed. It would prevent platforms from removing people saying the Sandy Hook shooting was a good thing, as long as it's done in a political context. Spam prevention by email couldn't be done if somehow they slip in something political or religious in nature. For example, Jesus wants you to buy my products. Can't block those spam emails. What if Etsy doesn't want to sell a swastika? That's a political symbol. That's political speech. This bill would force them to provide that type of content. That's the type of lawful but awful content that this bill would authorize and force platforms to keep up. Now, another question was on the First Amendment. Well, this is clearly unconstitutional. It's not just my opinion. Many of the largest law firms in the world have done legal briefs analyzing it. When the law was passed by the legislature of Utah, Governor Cox vetoed it on First Amendment grounds, and a number of cases from the Supreme Court. I'll just name a couple: Miami Herald versus Tornillo, Turner Broadcasting versus FCC, Reno versus ACLU, Brown versus Entertainment Merchants Association, and National Institute of Family Life Advocates versus Becerra, all hold that the state cannot compel a private business to host speech or say something it doesn't want to say. This would be unimaginable if the government said that the Portland Press Herald had to host speech or do an op-ed or host an op-ed that it didn't like because the op-ed was political or religious in nature. But somehow, if you're an online platform, you do have to. Now, I did hear Mr. Sevier complain that platforms have been deceptive or fraudulent. Well, the good news is that you don't need this legislation. If any business is engaged in unfair or deceptive trade practices, your state AG can take an enforcement action today under existing state and federal law. And 3 minutes are up, so I will stop there and welcome any questions or comments you may have. Thank you.
Thank you very much for your testimony and for being right on the money in terms of time. Are there questions for Mr. Sabo? The first hand I saw was Representative Thorne, followed by Representative Libby.
Thank you, Mr. Chair. Mr. Sabo, I missed at the beginning who you represent.
I represent NetChoice. We're a trade association that promotes free expression and free enterprise.
Okay, thank you. And a follow-up, if I may, Mr. Chair?
Yes, you may, Representative Thorne.
Mr. Sabo, did you show up today and testify on your own accord, or did somebody ask you to testify today?
I testified on my own accord. I mean, I represent NetChoice, but to the extent that anyone told me, no, it's because I'm here and it's because I represent NetChoice.
You showed up because you, on your own accord, nobody requested that you show up and represent NetChoice.
I'm here on behalf of NetChoice, but I also believe what I say. So I believe, and I will vehemently.
Mr. Chair, may I reform the question?
I'm not. He said he represents an entity.
I just wanted to pose it in a yes or no question.
Absolutely.
Mr. Sabo, are you here today on your own accord?
Yes.
Thank you.
Thank you, Representative Thorne. Representative Libby.
Thank you, Mr. Chair. Mr. Szabo, first of all, I must have missed it. I was absent for a quick moment. You must have already said where you reside.
Rockville, Maryland.
Yes,
Thank
Rockville,
you.
Maryland.
Thank you. My question is, you mentioned the Press Herald, and thank you for bringing that up. It's my understanding that the Press Herald is a publishing entity that directs and edits what they put out. Are you comparing Facebook to that? Does Facebook direct and edit what they put out as a publishing entity?
Ma'am, they are not a publishing entity. However, that is only applicable to the extent that we talk about Section 230. I did not mention Section 230 at all in my testimony. All I spoke about is the violations of the First Amendment, which Just like the Herald, Facebook is a private business, and the state cannot compel a private business to host content it does not wish to host.
I appreciate that. My specific question is Facebook a publishing entity like the Press Herald? I guess that's a yes or no question.
They are not a publishing entity like the Press Herald.
Thank you.
Are there additional questions from committee members for Mr. Szabo? Seeing none, thank you very much for your time and testimony today, sir, and taking time out of your day to present it.
Thank you very much.
The next person that I have registered to testify against LD 1609 is John Olson. I would ask for Mr. Olson to be moved over to the panelist status. Mr. Olson, welcome to the Judiciary Committee. As you've heard me say to others, I will start a 3-minute clock when you begin testifying, and please let us know your place of residence at the outset of your testimony. Welcome, and begin when you're comfortable.
Thank you, Chair Harnett and members of the committee. As you mentioned, my name is John Olson. I am the Northeast Director of the Internet Association, IA, and I reside in Albany, New York. IA is the only trade association that exclusively represents leading global internet companies on matters of public policy. Our mission is to foster innovation, promote economic growth, and empower people through the free and open internet. We believe the internet creates unprecedented benefits for society. As the voice of the world's leading internet companies, IA works to ensure legislators, consumers, and other stakeholders understand these benefits. IA respectfully opposes LD 1609, which would create actionable claims when privately owned internet platforms exercise their First Amendment right to remove harmful content. While IA shares the author's interest in promoting diverse online discourse, this legislation would prevent service providers from taking critical actions for the safety of their users. Despite the characterization of social media platforms as digital public squares, the fact remains these forums are still controlled by private entities. Section 230 of the Communications Decency Act prohibits liability in cases of content moderation. Without Section 230, the law could treat a provider who turns a blind eye to harmful content more favorably than a platform that takes action to try to protect consumers. With its passage of the law in 1996, Congress made it clear its intent that Section 230 should empower providers to engage in content moderation. To realize the full benefits of online services, it is critical that service providers are able to set and enforce robust rules designed to protect the quality and integrity of their services. Today, providers regularly act against spam, malware and viruses, child sexual abuse material, scams, threats and harassment, impersonation, non-consensual intimate images, and other content that, regardless of whether illegal or legal, is harmful to the users of their services and the public at large. LD 1609 would put the safety measures providers take daily at risk by seeking to limit the scope of enforcement that can be undertaken without the threat of litigation. Consumers will not benefit from this. Further, LD 1609 would put online companies in the position of defending content moderation decisions in a court of law. Regardless of whether a platform was acting appropriately under the bill, individual users would still be empowered to sue and take the company to court to challenge content decisions. This would be an untenable solution, leading either to more curated internet, where less diverse voices can be heard, or a return to a lawless internet, where harmful content overwhelms the healthy discourse and exchange of ideas that we all desire. For these reasons, I strongly urge the committee not to advance LD 1609. Thank you for your time, and I will happily take any questions.
Thank you very much, Mr. Olson, for your time and testimony today and for presenting it to the Judiciary Committee. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Mr. Olson. A couple questions. One is, you mentioned harmful content early on in your testimony, and I'm a little bit curious about how that is defined exactly. I'll give you an example. I, at one point, had an acquaintance who was not allowed to post on Facebook for 30 days over this past winter because of posting up a political meme. There was nothing sexual about it. There were no swear words. There was nothing that I think your average person would think was inappropriate. At the same time, multiple other friends had complained to Facebook because there was a suicide of an acquaintance that was still live on the website for quite some time. So I'm just curious about how that harmful content is defined. These seem like pretty clear. One seems pretty harmful while the other does not. So I'm just curious if you could expound on that a little bit. What exactly is harmful content?
Well, I think harmful content is defined differently between platforms and is found in their user guidelines. I can't expound accurately on what it actually is defined as in each user guideline. What I will say is, in the cases you represent, that most likely the content moderators did not actually get to the video in question, but either an algorithm or for whatever reason, whatever timeline this meme was posted in, it may have been boosted to the front based on whatever activity was happening on a national level. So with respect to political memes or any other content that may be in so-called gray area, it really is just the exercising of the private entity in determining that content needs to be removed.
I have another question, Mr. Chair.
Yes, you may, Representative Libby, go ahead.
Thank you. So my question is, are breach of contract, bad faith, unfair dealing, deceptive trade practice, false advertising, and fraud protected forms of speech for purposes of the First Amendment?
I don't think so, but that is not what we're referring to in this bill.
Thank you.
The representation of breach of contract is not the same as a private entity exercising its First Amendment right to remove content.
Representative Thorne.
Thank you, Mr. Chair. Mr. Olson, have you read the exemptions?
Of the bill?
Yes.
Yes.
And do you find those to be acceptable?
I find the bill to be unacceptable in general.
I meant the exemptions per se.
They are a good start, I would say, but the entire bill has severe issues with the First Amendment and Section 230 of the Federal Communications Decency Act.
Okay. Follow-up question, if I may, Mr. Chair.
You may, Representative Thorne.
Thank you. The bill is an act to stop social media censorship. You said you're the Northeast Director of Internet Association?
That's correct.
What's your definition of censorship?
I'm not a legal attorney. I don't want to start defining things. My idea is irrelevant to this. Censorship is not the issue with this bill. The bill is compelling private entities to cease removing content based on a certain point of view. Censorship is not an issue with a social media platform. If the government were to compel a company to censor certain people, that would be an issue of censorship.
Were you aware that the title of the bill is an act to stop social media censorship?
Yes, I'm fully aware of the intent.
But you don't know
what
you don't know what the definition of censorship is. Okay, thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions for Mr. Olson? Seeing none, thank you very much for your time and testimony today and taking the time to present it to the committee.
Thank you, Chairman.
That is all the persons that I have signed up to testify in opposition to LD 1609. But I will go to the attendee room to make sure that I'm not missing anyone. Are there any persons in the attendee room who wish to testify in opposition to 1609? If so, please raise your electronic hand. And seeing none, I do have one person who is signed up to testify neither for nor against. So I would ask the committee clerk to please move over Samantha Fillmore from the Heartland Institute. And welcome, Ms. Fillmore. As soon as you are comfortable, activate your mic and camera, and please begin your 3-minute testimony, and welcome to the Judiciary Committee.
Hi, thank you, Chairman and members of the committee. My name is Samantha Fillmore. I am the State Government Relations Manager at the Heartland Institute, which is based out of Chicago, Illinois. That's where my town of residence is. We are a national nonprofit think tank. This year, we have seen and worked on 59 pieces of legislation in 29 states, all attempting to challenge big tech in some way and asking all of the same questions that you are. How can we protect our constituents and also deal with this very lofty constitutional issue? However, I would like to point out that the volume of the bills across the nation through this legislative session is indicative of the fact that so many lawmakers and constituents and Americans are realizing that we're entering into a potentially dangerous time for free speech in our society. These tech platforms have become omnipresent with all political speech and expression, and yet we see these companies sometimes flippantly deciding to take things off, as some of the representatives today have mentioned examples of. Opponents of this legislation would argue that censorship is appropriate because market forces have allowed these titans to rise to power. And to that, I would submit to you that these instances are not a product of a healthy free market, but rather the result of a corrupted market based on the liability, gifts, and protections provided to these companies through the Federal Communications Decency Act. Big tech enjoys monopoly-like protections from the federal government, and this legislation would begin to fix the corruption in that market for your constituents. 72% of the United States population used social media in 2020, and ad revenue for these companies reached $40 billion in 2020. So this is not a small or insignificant issue. According to a Pew Research study, 70% of, or three-quarters of United States adults feel that big tech intentionally censors political speech based on viewpoints that they may objectively deem objectionable. So this bill would send the message to your constituents that you are concerned about protecting their First Amendment rights and that public speech is sacred in your state. Finally, I would like to submit to you that on the issue of freedom of speech, more speech is always a solution, not less. And again, I've been working on all these states, 29 states while moving through this. If you have any questions for me, I would happily answer them, but I also don't want to take up any more of your time. So thank you, committee and chairman, for your time today.
Thank you very much, Ms. Fillmore, and thank you for presenting your testimony in 2 minutes and 30 seconds. Greatly appreciated. Are there questions for Ms. Fillmore? Representative Libby.
Thank you, Mr. Chair, and thank you for being here, Ms. Fillmore. I'm interested, you mentioned so many other states that you've seen this legislation or worked on this legislation. Are there any states where similar or same legislation has been passed? I know we're just in the public hearing part of this process, and I'm curious to know what is going on in other states.
Absolutely. So this is a brand new issue that all of these bills came up very quickly, right in the beginning of the year. So it has not a single bill has been signed by the governor yet, by any state governors yet, but we have gotten them through both houses in a number of states, including Texas and Florida, namely. So especially in Florida, we are just one step away. We're waiting. It's on DeSantis' desk at some point. So we're definitely working it through all of the stages, through all of, as you know, the many committee meetings and many House votes and everything else. But nothing has officially turned into law as of yet. It is still only May, though, as you know.
Thank you very much.
Thank you.
Thank you, Representative Libby. Are there additional questions for Ms. Fillmore? Senator Keim.
Thank you, Mr. Chair. I'm sorry that I won't be able to turn on my video at this time, but I did have one question for Ms. Fillmore, which was one of my great concerns around this topic is the idea of the monopoly that's happened with the large tech, and now they've all combined with one another. And so then essentially their policies can cancel out what we've all come to expect. And I just wondered if you could speak to the idea around a monopoly. You know, I am looking for solutions, and your seems to be a voice that might be able to help offer some opinions on that. Thank you.
Thank you, Senator Keim. Yes. So, I mean, as we all know, it is no secret that the federal government in recent years has had many congressional hearings.
Ms. Gilmore,
Yeah.
could you move a little closer to your microphone? I know I'm having difficulty hearing.
I'm
Thank
sorry.
you.
Is this better, Chairman?
Much better. Thank you.
As I was saying, it is no secret we know that there have been federal congressional hearings on big tech as a monopoly in recent years. My work is primarily with state legislatures, and this is why I love legislation such as this, and we've been working on it because it does fit into the exemption clause of the federal statute. And it is my personal belief that as representatives of your constituents, you have so much more power and authority and the ability to make truly good decisions on what you think is best for your constituents and citizens of Maine. So this legislation does slide nicely into a state exemptions. It's a subsection E, subparagraph 3 for section 230 federally. And that is where we believe that the best starting point is to challenge these monopolies, these big tech monopolies, if you will. And opponents of this legislation would claim that this will become justiciable very quickly, and that big tech will then want to sue states and other things like this, in which that would go into a federal court hearing, which members of the Supreme Court have already spoken out against this and in favor of legislation like this, and challenging the question as to whether big tech does have truly a First Amendment right, as they are not a single actor, but rather like a bulletin board. So yes, in terms of taking on these very large corporations, where do we begin? That is the question. And that's why this legislation is very important, and why we are all here hopefully beginning to think and send the message to your constituents that this is important and this is something you care about.
Thank you for that response. It was helpful in helping me broaden my viewpoint on this. Thank you.
Thank you, Senator Keim, and thank you for your response, Ms. Fillmore. Are there additional questions for Ms. Fillmore? Seeing none, thank you very much. We greatly appreciate you taking the time and presenting your testimony to the Judiciary Committee on LD 1609 this afternoon. Thank you.
Chairman.
That exhausts the list of persons that I have registered to testify in any capacity on LD 1609. As I tend to do, I will check the attendee room one more time to ask if there's anybody who wants to be heard neither for nor against LD 1609. And seeing none, having heard all of the testimony presented by members of the public present today, I will close the public hearing on LD 1609. I thank the bill sponsor for bringing the bill forward to the Judiciary Committee, and thank you for your time today. I will now turn to LD 1612, an act to facilitate children's testimony in certain sex crime cases, and I would welcome the bill's sponsor, Representative McDonald. Representative McDonald, nice to see you again, even if in a little box. But as soon as you are comfortable, please begin your presentation of LD 1612. And welcome.
Thank you, Chair. Senator Carney, Representative Arnett, and distinguished members of the Joint Standing Committee on Judiciary, I am Representative Genevieve McDonald of House District 134, and I am testifying before you today as the sponsor of LD 1612, an act to facilitate children's testimony in certain sex crime cases. We have learned through the course of the pandemic that it is possible to effectively communicate remotely, even on serious matters. All courthouses in Maine are now equipped with the technology and knowledge to make this possible. I recognize the rights of the defendant to confront their accuser, but we must also find a way to balance the emotional and psychological well-being of the child who is testifying. Audiovisual platforms such as Zoom do allow for communication to occur in real time and for a witness to be cross-examined in view of a jury, while also providing a sense of safety and security for the child that cannot be achieved in open court. As others will testify today, it is true that this legislation has been proposed before and has failed, but there is a reason it continues to be reintroduced. In most cases of sexual abuse, the perpetrator is a trusted family member or close contact. Abusers use intimidation, threats, and manipulation to keep a victim from disclosing, and many children are fearful of what will happen to them, their family members, or their pets if they tell anyone about the abuse. Children who are alleged victims of sexual assault are some of the most vulnerable among us. In my district right now, there's a pending sexual abuse case. The alleged victim is a petite 10-year-old girl. The alleged abuser is a 46-year-old man who lives with the alleged victim. While he has not been convicted of the crime of sexual abuse of a minor, he has been convicted of 5 counts of misdemeanor assault and 1 count of felony aggravated assault. Additionally, he has a documented history of violence and alcoholism. It is understandable that a young alleged victim may be intimidated by testifying against him in open court. This legislation will continue to be reintroduced until we are willing to put in the work to find a path forward that will protect our youngest and most vulnerable victims when they testify on these heinous crimes. Until that time comes, alleged perpetrators will continue to go free when a child or their family is too intimidated by the court process to want to proceed, believing that going to court will put their child through additional trauma. In Maryland versus Craig, the Supreme Court of the United States recognized that the Sixth Amendment right to confrontation is not absolute and that remote testimony is permissible if the state makes an adequate showing of necessity. Maine is an outlier in not having this framework. The majority of states have provisions in statute. We have the technology, resources, and knowledge to think more creatively about how to balance both the rights of the victim and the rights of the accused. Please join me in finding a path forward. Thank you for your time and consideration, and I'm happy to answer any questions from the committee.
Thank you very much, Representative McDonald, for bringing this bill forward and presenting it to the Judiciary Committee this afternoon. Are there questions from committee members for the bill's sponsor, Representative McDonald? Representative Evangelos.
Hi, Representative McDonald. Do have my mic on for a change. I am concerned about the Sixth Amendment provision, and I think you're aware that the reason the bill failed in the past was that it was pretty much found to be unconstitutional, aren't you?
I am aware of that, but it's also not absolutely unconstitutional. There are provisions that we could craft that would still allow for victims to testify. The state would just have to show that it was of necessity. I also would like to raise the point that when this bill was introduced in the 126th, it also was at the very end of session. And so I think it's unfortunate that now, again, there really hasn't been enough time to work on a solution moving forward. It's always been a last minute piece of legislation.
And the second question I had was, I don't know if you were aware, but we had a variety of very, very serious cases across the country. There was a major one in Massachusetts, another one in California, where because of the provisions that the court allowed for the lack of confrontation, that the defendants were sentenced to very, very severe prison terms, only to be freed from prison when it turned out the children lied. And they lied because they were encouraged by malicious and vindictive counselors. And what kind of protections are you going to put forward for the right of the defendant who's innocent?
The judicial system is not perfect, and there's certainly room for improvement. Conversely, I would offer that many perpetrators go free because the victim does not testify. For any further legal questions, I'm certainly not an attorney, and there are other folks here today that are more schooled in this topic.
One more question, Mr. Chair. You know, if you're innocent and you get sentenced to a cage, you're comfortable with a refrain that the judicial system isn't perfect?
Is that a question for me? Obviously, I don't want to see anybody who is innocent. I'm sorry, I have a call coming in. Obviously, I don't want to see anybody who is innocent go to prison, and I sort of resent the implication, but certainly I think that we can craft a path forward that would take that possibility into consideration in all of our laws and penalties, not just this one.
Well, I apologize that you resent the implication, but you raised it.
No, you raised it, but thank you for the question, Representative.
Are there other questions from committee members for the bill sponsor, Representative McDonald? Seeing none, Representative McDonald, thank you for bringing the bill forward to the committee today. As the bill sponsor, you're welcome to stay on as a panelist for the duration of the public hearing if you choose to do so.
Thank you, Chair.
You're very welcome. I am now turning to persons who have registered to testify in support of LD 1612, and I will turn to Elizabeth Ward Saxel, Ms. Ward Saxel, nice to see you in front of the Area Committee again. You know the drill. You'll have 3 minutes. I'll start the clock as soon as you're comfortable and begin speaking.
Yes, thank you very much, Senator Carney, Representative Harnett, members of the committee. My name is Elizabeth Ward Saxel. I'm here today on behalf of Maine Sexual Assault Support Centers in favor of LD 1612. I'm not going to actually read my testimony. I'm going to just try and respond to some of the thoughts that have been shared to date. I do talk about the challenges for very young survivors of sexual violence in this context. But I think that there are ways, in fact, I know there are ways that still allow for the full ability to confront the accuser, that would allow for full representation, cross-examination, but without having that child in the same physical room facing the individual. I would also say that I don't characterize what happened the last 2 times this bill was brought forward as having failed due to constitutional issues. I think in one case, CLAC said that essentially we already have the ability to do this. And I think that memo, I don't know if they're pulled it up for this, but I do have it, not here, but I'd be happy to send that out to the committee. And so one of the things that they had indicated at the time was, well, they can do it, but now the court said, well, we don't have the resources to be able to do this kind of electronic closed circuit testimony. They worked with the courts to buy some equipment for them for a pilot project, which I don't know if it ever got off the ground. So, I mean, I think that within this very narrow context, again, of cases, you know, I would not characterize it as having failed based on that situation. But, you know, I can't remember all the bills perfectly that I was in the room for, so I may be misremembering. I also just wanted to add that we've got a long history of working with multiple partners to come up with perspectives, solutions that weigh various interests. Mr. McKee, I think, will attest, I think he did, as I did in your orientation, to the fact that he and I have sat down many a day and come up with solutions to complex problems along with other parties that really balance the rights of victims and those who are accused. And I've got every reason to believe that in this case as well. So I'd be happy to answer any questions you might have and would be happy to be here for the work session.
Thank you very much, Ms. Ward Saxel. Are there questions from committee members for Ms. Ward Saxel? Seeing none, again, thank you very much for your time today, and thank you for presenting your testimony to the Judiciary Committee.
Thank you.
That exhausts my list of persons testifying in favor of LD 1612. I will turn to the attendee room and ask if there are any persons in the attendee room who wish to speak in favor of LD 1612. Please raise your electronic hand. Seeing none, I know that we had one person registered to testify in opposition to LD 1612. However, I do not see Ms. Megan Sway in the attendee room, but I will ask if there are any other persons who wish to. I will note that Ms. Sway did file written testimony and would encourage committee members to please read that. But I will ask if there are any persons in the attendee room who wish to speak in opposition to LD 1612 to please raise your electronic hand. And again, seeing none, I will ask if there are any persons in the attendee room who want to speak neither for nor against LD 1612 to please raise your electronic hand. And again, seeing none, have heard, I'm sorry, Representative Moriarty, you had a hand up?
I do, Mr. Chair. I understood from Ms. Ward Saxel's comment that some people with legal expertise might be following her. So I held off on asking her a question. Apparently there is no one yet to speak. So may I ask her a question in the off chance she may be able to?
Ms. Ward Sexel?
Yes.
Yeah, she is still in here as a panelist, and she is right back in front of us. So go ahead, Representative.
Okay,
Moyer.
you're terrifying me though, but
Okay.
have a run at it.
Here goes. I understand. I'm looking at subparagraph 3 of the bill, the titled exception. I don't know if you have that before you.
Pulling it up right now. Sorry, Representative. Sorry, I just closed it. All right. Yes, I have it. I have the bill up on me. I'm sorry. Section what, Representative Moyer?
The final one, 3.
Exception, yes.
Okay. So I understand the second clause, which deals with the right of confrontation coming from the 6th Amendment. I don't understand the first clause, which indicates the bill doesn't apply if the defendant is acting as his or her own attorney. Do you know why it's phrased that way?
I don't. I can speculate, but I don't.
Okay, good. Thanks.
Sorry.
Okay.
Okay, thank you, Representative Moriarty. So again, and that concludes your questioning, Representative Moriarty? Your hand
Yes,
is
I'm
still
done.
up.
Thank you. Yep.
Thank you. So with that, I'll check the attendee rooms to make sure that Ms. Sway has not appeared. And with that, having heard from all members of the public present to present testimony today, I will close the public hearing on LD 1612 and thank the, I'm being told that Representative McDonald raised her hand.
Oh, no, that's okay. I'm happy to, I will attend the work session.
Oh, okay. Thank you. Whoops. Opening too many boxes here. I'll be back. Again, seeing nobody else registered or indicating an interest in testifying today, I will close the public hearing on LD 1612 and look forward to seeing the bill sponsor at the work session and thank the bill sponsor for bringing the bill forward. That brings us to LD 1617, an act to establish and practice restorative justice. And I welcome in the bill's sponsor, Representative Rachel Talbot Ross, to present the bill. Representative Talbot Ross, you'll be moved over as a panelist. It looks like you have been already. Welcome back to the Judiciary Committee. As soon as you feel comfortable, please present LD 1617.
Thank you. I just want to make sure I can check my audio because I've had trouble with my internet service. Can you all hear me?
So far,
Okay.
so good.
Great. So Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary, my name is Rachel Talbot Ross. I represent House District 40 in Portland and serve as the Assistant House Majority Leader. Thank you for the opportunity to present LD 1617, an act to establish and practice restorative justice. As members of this committee have heard earlier this session, restorative justice is an approach that focuses on rehabilitation of offenders through reconciliation with those who have been harmed in the broader community. It is a value, an ideology, and a practice. In terms of this specific practice, the 3 fundamental tenets are as follows. Number 1, repair. Crime causes harm and justice requires repairing that harm. 2, encounter. The best way to determine how to do that is to have the parties decide together. And 3, transformation. This can cause fundamental changes in people, relationships, and communities. Research shows that restorative justice programs improve outcomes and lower recidivism. They are also very cost effective. Over the past 20 years, Maine has seen a growing movement of citizen-led restorative justice organizations. Restorative justice practitioners will tell you of the transformational impact and incredible potential of restorative justice practices. On a personal level, I have been involved in restorative justice for years and have witnessed firsthand its potential to address root causes of harmful behavior and support healing throughout a community. To me and to the restorative justice practitioners, this is clear. We must focus on restoration, not retribution, in our justice system and beyond. That is why I am so deeply committed to alternative methods of addressing harm and resolving conflict. Our intention with introducing LD 1617 is to include a definition of the benefits of restorative justice in Maine's criminal code. Restorative justice practices are briefly referenced in both Title 15, subsection 3204, and Title 34A, subsection 1214. Stakeholders have been working hard to help with the definition. I am attaching a draft amendment to this testimony. However, I recognize that more work is still needed and hope to connect with stakeholders and practitioners of restorative justice so that we can bring you a final product at the work session. As members of this committee know, I am also sponsoring LD 1226, which directs the Permanent Commission on the status of racial, indigenous, and Maine tribal populations to review restorative justice legislation from across the country and make recommendations on policies we can consider here in Maine. I ask you to support this bill, LD 1617, so we can move forward in incorporating restorative justice this session, while also pursuing the path laid out in LD 1226 to identify additional policies that will improve our justice system and outcomes, reduce recidivism, and save taxpayer dollars. I'd be willing to walk through the amendment with you, and thank you for your time and attention. I'm happy to answer any questions.
Thank you. Thank you very much, Representative Talbot Ross, and thank you for bringing the bill before us and presenting your testimony today. Are there questions for the bill sponsor, Representative Talbot Ross? Representative Moriarty.
Thank you, Mr. Chair. Actually, my question goes to you, if it's an appropriate time to do that.
It depends on what the question is, sir.
Okay. It has nothing to do with the merits of the bill, but yesterday we had a work session on a concept, on a bill that had been heard at public hearing as a concept. And yesterday, a 12-page bill was submitted to us for the first time. And we decided to return it for public hearing. We're in a serious time crunch. If the final draft is not yet available, I think we're going to end up having to do the same thing. And in anticipation of that, and given the time demands, I think we need to reset the public hearing when the final bill is done.
Well, we do have an amendment in hand that was presented today, but let me turn to the bill sponsor to see. The amendment that we received yesterday was a 12-page document that was.
Well, it was the bill itself.
Correct. It was the bill itself. But let me turn the question to the bill sponsor first, if I could, before making a decision.
Thank you, Mr.
Talbot Ross.
Yeah, thank you, Mr. Chair, and thank you, Representative, for the question. This is a really simple move that we're trying to make. What we noticed in the amendment that we provided to you is that we, in 34A, MSRA 1001, that's where all the definitions reside, Representative. And what we're doing is we're adding the definition of restorative justice in the definitions. Unfortunately, what we did is we pulled the restorative justice program definition from the juvenile code and put it into the definitions. Really, it's not a program. In 34A MSRA 1001, we need to put the definition of the benefits of restorative justice. So it's a very simple fix. We could have fixed it today and brought it to you today, but we just noticed that we picked up the definition of program versus restorative justice benefit. I mean, I can have that to you by the end of the day. This is not a whole rescheduling of a public hearing kind of thing. It's a simple fix, with all due respect.
Mr. Chair?
Yes, Representative Moriarty.
Okay, and to Representative Talbot Ross as well. I don't question the motives or again, the merits of this at all, but we had this discussion yesterday and we decided that we have an obligation to notify the public in advance of what it is our hearing is all about and not after the fact. And we sent a bill back for a second public hearing because we didn't have substance before us at the time of the first hearing. And we're sort of in the same position right now. I haven't seen the amendment, but I gathered from your comments, Representative, that there's more to come. So it may be simple, but still the public hasn't had an opportunity to see it.
The representative, and I'm very sensitive to your concern, particularly since we had a similar discussion 24 hours ago. The amendment is in the portal. It was added to the portal, I believe, today.
Well,
I it's not a lot of notice. We don't have a lot of notice on a lot of bills today. What I would do to proceed is to take the testimony of those that are here today. If when we receive a final amendment, you still are, the committee is of the position that it needs to be reopened to a second public hearing, then we will consider that at that time. I know that's not a complete answer, but it's the best answer that I can come up with right now. Thank you. And I don't know the order of the hands that went up, so I will begin with Representative Libby and then Representative Thorne.
Thank you very much, Mr. Chair, and thank you for being here today, Representative Talbot Ross. My question is, I do see your amendment here, so thank you for submitting that. And I, of course, not having 34A MRSA 1001 in front of me, am I correct in thinking that what you're saying here is that this is a changing of definition versus the actual program mechanics? Am I understanding that correctly?
So thank you for the question, Representative. Yes, I'll be very clear. In 34A, Title 34A, subsection 1214, which is the Office of Victim Services under Corrections, that's where we're at in law. It under F, I'm sorry to be so specific, but it references that this Office of Victim Services shall assist victims with obtaining victim compensation, restitution, and other benefits of restorative justice. The problem is, Representative, that we don't define what the benefits of restorative justice are. So stakeholders and practitioners, we want to make sure that the definition of the benefits of restorative justice lies somewhere in our definitions in the criminal code. So all we're trying to do is provide a definition of benefits of restorative justice. Unfortunately, we picked up the definition of restorative justice programs from Title 15, which is the juvenile code, as the amendment that I sent you. So the simple fix is, it shouldn't read restorative justice program, it should read restorative justice benefits, so that now we have a definition of the benefit of restorative justice in Title 34A, and not the definition of a program that's found in Title 15.
And if I could follow up, Mr. Chair.
Yes, you may, Representative Libby.
I had very similar concerns and questions as Representative Moriarty presented, but in hearing your explanation, I wonder if part of the amendment could be a change in the title, because the title indicated to me that we're talking about a wholesale program, and I'm getting from you that that's not what we're looking at. So I just would like to help with any confusion there.
If I may, Mr. Chair.
Yes, you may, Representative Talbot Ross.
Thank you, Representative Libby, for that clarification. the title of the bill did not get amended in the amendment. So my apologies. Okay. I'm not presenting a whole restorative justice practice program at all. We're just trying to get a definition in the criminal code to match the statute that already exists, of which there is no definition. So my apologies, and I thank you for the ability to clarify this.
Thank you very much for working through it.
Thank you.
Thank you, Representative Libby. Representative Thorne.
Thank you, Mr. Chair. Representative Talbot Ross, hopefully this is a simple question, but we're all just trying to wrap our heads around restorative justice, where the victim and the perpetrator get together to better understand what happened in an alternate solution, and I understand the benefits of it and so forth. My question to you is, what prevents a judge from using what restorative justice is today without this?
So a couple of things, Representative. One is this section of the criminal code is not about sentencing. So this has nothing to do with sentencing. We are trying to put a definition of the benefits of restorative justice in Title 34A, which is about corrections under the Office of Victim Services. So this is long after the fact of sentencing. I'm not touching the sentencing statutes in this bill. So the answer to your question is, we'd have to go to this, we'd have to amend the sentencing statutes in order for restorative justice to be an alternative sentencing option. And this is not that bill. Because again, we're only amending the statute to include a definition of the benefits of restorative justice as it relates to this particular statute.
May I rephrase my question, Mr. Chair?
Yes, you may, Representative Thorne.
Thank you, and I appreciate your indulgence and patience with me. An act to establish and practice restorative justice. At what point does this involve the victim and the perpetrator of a crime?
If I may,
is it at all in the judiciary process, or is it at the end more of a social program versus a corrective behavior imposed program by a judge or social worker, whoever? I'm just trying to figure out at what point you're going to establish a restorative justice program. Who imposes, and I'll use the word impose, just because obviously you're looking at establishing it to have, am I using the correct terminology, a victim and a perpetrator confront each, to come face to face? So at what point does that happen? At what point is it either ordered or suggested, and who would do that currently, and should this become a law? Those are the two distinctions I'm looking for.
Yeah, Mr. Chair, if I may, what it occurs to me, and I have to go back to my thanking Representative Libby. It appears that there's a lot of confusion because of the title of the bill, and so I apologize to the committee. We should have amended the title while we amended the bill. But LD 1617 was a concept draft originally to do exactly what you're referencing, Representative Thorne. The concept draft was to establish and practice restorative justice to the degree that you're inferring. So you are correct in trying to bring that understanding to this discussion. My response is that this bill is no longer trying to establish this practice, because we've amended the bill to only look at placing a definition of the benefits of restorative justice in statute, not anywhere near the sentencing statutes, but in the Office of Victim Services. So I'm just saying that you're right, Representative Thorne, in asking your question.
Just not on this bill.
Because the title of this bill needs to be amended for the committee to keep up with where we're at in the process of this bill. And it does go back to Representative Moriarty's initial response, because it looks like it's completely different. But
you're right. You're right. That was my confusion.
Yeah, no, you're right. And so I apologize to the committee. What has happened is we took a concept draft that was called an act to establish and practice restorative justice. We took a concept draft, and I'm bringing you the amendment to the concept draft. That's what we're doing now.
Okay.
And I apologize. Representative Thorne, Representative Libby, and Representative Moriarty, you're all right.
So, and Rachel,
that helps.
I'm sorry, you done, Representative Thorne?
Yes, it does, Mr. Chair. Thank you. And thank you, Representative Talbot Ross. That helps greatly. Thank you.
And Representative Talbot Ross, if I might suggest it, this might become an act to define the benefits of restorative justice, because that's really what we're trying to.
That is correct, and I appreciate that suggestion, Mr. Chair.
Thank you. Are there additional questions for the bill sponsor? We only have 2 people signed up to testify, so I am going to proceed with the testimony of those 2 individuals. And if we determine at a later date that we need to schedule another public hearing, that's what we will have to do. So at that point, Representative Talbot Ross, as the bill sponsor, you're welcome to stay as a panelist for the remainder of the hearing, unless you have 13 other things to do, like most days. So at this point, I would bring into the panel the first of our 2 witnesses who have signed up to testify and are here today. And I would call upon, welcome back to the committee, Cushman Anthony. Thank you for appearing again, Mr. Anthony, in front of the Judiciary Committee. As soon as you are comfortable, please begin your 3-minute testimony, and I'll give you warnings when the time is running out.
Thank you. My name is Cushman Anthony, and I live in Yarmouth. I tried to figure out what Rachel Talbot Ross had in mind in the title, from the title of the bill, and I concluded that it was to increase the implementation of restorative justice in the criminal system. But in any case, I want to at least read my testimony, which I think, among other things, clarifies what restorative justice actually does as an educational piece. I am a retired lawyer and mediator. As I've said before, I was a member of the House of Representatives and member of this committee during the past 1986 to 1992. And I did speak about the resolve directing the Permanent Commission on the Status of Racial and Indigenous and Maine tribal populations to examine restorative justice. I think that's a great idea. This time, however, I'm speaking on behalf of the Maine Council of Churches, the leading organization of Protestant Christian churches in our state, representing 7 denominations, which include 437 churches with a total membership of more than 55,000 members. So it's not just me alone. I personally have found restorative justice an approach extremely effective in dealing with juvenile offenses. I began doing that in 1998. And I'm aware that the Cumberland County DA has also started using that approach successfully in dealing with a variety of adult crimes, and I applaud that. The process is normally precedes taking the incident to a court for an adjudication. And I don't know exactly how the benefits definition helps that, but in any event, here's how it typically works. Restorative justice can only be used effectively if the perpetrator has admitted to his or her actions and the victim voluntarily agrees to participate. The facilitator first briefs all parties as to what will happen in their upcoming face-to-face meeting. The questions typically follow the same format. Who has been harmed? What did the victim experience? What did the perpetrator experience? What can be done to restore peace and harmony to make things right? What can the perpetrator do towards that end? What changes need to be made to assure that it will never happen again? What can the community do to help with that? A plan of action is then developed with the help of the facilitator and with input from all parties that will restore harmonious relationships. That plan typically is then submitted to a court and becomes a sentence imposed by the court. Victims normally find greater satisfaction with this process and its result than the typical court proceeding. It is simple and effective. It should be widely used. Thank you.
Thank you very much for taking the time out of your day to provide your testimony, Mr. Anthony. And again, welcome back to the Judiciary Committee. I forgot that you had served here. Were we meeting together, you would have to bring some treats or baked goods for us, but you're off the hook due to the pandemic. Are there questions?
But I've appeared before you before and did that in the past before this committee.
But I don't think I was here, so it doesn't count. Are there questions?
I thought it counted.
Are there questions from committee members for Mr. Anthony? Seeing none, again, thank you very much for your time today. We greatly appreciate you being here.
Thank you.
Now call upon back to my list here, the last person that I see in the attendee room who is registered to testify, and that is Jan Collins, who's probably already been moved over by my clerk before I even ask. Ms. Collins, welcome back to the Judiciary Committee. As soon as you are comfortable, please begin your testimony, and I'll hold up a little yellow when you have 20 seconds left.
Representative Harnett and honorable members of the Judiciary.
Could you, Jan, I don't want to start the clock. We can't hear you. Can you get closer to your microphone?
I'm pretty close. You'll be looking up my nose if I get too much closer.
Well, maybe your volume is not up high. I don't know about anyone else. I'm having great difficulty.
Can you hear me now?
Not well. That has not been an issue in the past.
It has been an issue with my computer, so let me try this. Can you hear me now?
Much better.
Oh, thank you. Great. Terrific. I appreciate that. Representative Harnett and honorable members of the Judiciary Committee, my name is Jan Collins, and I am Assistant Director for the Maine Prisoner Advocacy Coalition. I'm here today to speak in favor of LD 1617, an act to establish and practice restorative justice. And I do understand that the title does not fit the bill at this point. A couple of years back, I had a conversation with District Attorney for Franklin, Oxford, and Androscoggin counties, Andrew Robinson. We were talking about how best to address our high incarceration rates. His suggestion was to have a victims' compensation fund for property crimes. Maine's current fund is for victims of violent crime. there is no fund for property crimes. DA Robinson had found that victims of theft or damaged property wanted most to have their property repaired, replaced, or returned. Once made whole, they were no longer invested in punishment. The courts were then free to assign community service, repayment of the compensation fund, and/or jail time as the court saw fit. Without just compensation, the victim was forced to carry their pain and always demanded jail time. What the victim most wanted was to have their wound acknowledged and their loss made whole. That is exactly what restorative practices do. The benefits are not only to the victim, but also to the community. Individuals who commit a crime, but are held accountable for the repair of harm, are much less likely to commit another crime. Youth who have participated in restorative justice programs have recidivism rates in the single digits, while those who are incarcerated have rates between 60 and 70%. According to my computer dictionary, justice is the quality of being fair and reasonable, and to restore is to repair or to give something previously stolen, taken away, or lost back to the original owner or recipient. These two things are often lacking in our current system. While the Permanent Commission on the Status of Racial, Indigenous, and Maine Tribal Populations is tasked with incorporating restorative justice into the Maine Criminal Code, this bill will place into the code a definition for restorative justice, a first step in creating a system of justice which heals our communities and increases our safety by reducing recidivism. Thank you for your support of LD 1617, an act to establish and practice restorative justice. Thank you.
Thank you very much, Ms. Collins, for being here again in front of the Judiciary Committee and presenting your testimony today. I will now turn to questions from committee members. Representative Thorne.
Thank you, Mr. Chair, and welcome, Ms. Collins. And you are the perfect person to ask this question of, and I always like to play devil's advocate and look at the pros and cons. Restorative justice has been around for a long time. I can remember doing something that I pulled up vegetables from a neighbor's garden when I was a kid, and my parents found out about it. And the next spring I had to go help the people plant their seeds the next year, as a way for me to appreciate what I had done with the vegetables. My question to you is, have you ever seen where a victim and a perpetrator have agreed to get together, but it didn't turn out right? It didn't help, or it backfired, for lack of a better word?
Thank you for the question, Representative Thorne. And I have to confess, I have not participated in restorative justice. And I think that question would be best given to someone who has and is familiar with it. I do know that restorative justice program is not simply based on two people agreeing to sit down together. There's a lot of preparation that has to be done in advance for both parties, both the person harmed and the person doing the harm. And in that process, they're able to make it very clear what the expectations are for both sides of the agreement. My understanding from people that I know who have worked in this field, that it is almost never goes awry because they have so well prepared both parties. But I would never use the word never in that situation, because that one will come back to bite you. But for the most part, I think it's pretty successful.
Okay, thank you. I just thought maybe where you're on the front line as the prisoners advocacy program, that you would have firsthand knowledge. So thank you. I appreciate that.
Thank you.
Thank you, Mr. Chair.
Thank you, Representative Thorne. Representative Hagan.
Thank you, Mr. Chair. It's nice to see all you folks. I don't know who my question is for, whether it would be for you, Ms. Collins, or Mr. Anthony. Maybe you guys could decide. I was thinking about this and I never had an opportunity to ask in a different restorative justice bill a while back, but I'm back to my same question. What if the victim does not want to sit and talk with the offender? It's too painful.
Then they would not, thank you for the question. That's a good question. It only works if both parties are willing and ready to do it. And not just willing, they have to be ready. So there would not be a restorative justice process if the victim was not ready or willing to do so.
So can I ask him another one? Just quickly.
Yes, you may, Representative Hagan. Go ahead.
Thank you. With this bill here, as I'm pretty new to it, as the amendment, I did read the amendment before the committee meeting. So if I'm not willing, or whoever, the victim is not willing, then the courts just revert back to what's normal. Okay.
That's my understanding, yes.
All right, thank you.
Thank you, Representative Hagan. Are there additional questions for Ms. Collins? Seeing none, thank you very much for testifying today. We appreciate your time.
Thank you.
That exhausts my list of, I'm using that word exhaust a lot. I think that might be telling me something.
Freudian.
Exhaust the list of people that have registered to testify, but I will check one more time to see if there is anybody in the attendee room who wishes to testify in favor of LD.
Are you testifying right now?
1617. And seeing none, I would ask if there are any persons in the attendee room who wish to speak in opposition to LD 1617 to please raise your electronic hand. And seeing none, I would ask if there are any persons in the attendee room who want to testify neither for nor against LD 1617 to please raise your electronic hand. And seeing none, I will now, having heard from all persons present wishing to present testimony, close the public hearing on LD 1617. Thank the bill sponsor for bringing the bill forward.
I want to thank you, Mr. Chair, and all the members of Judiciary. My apologies again for the confusion. Prior to the work session, you will have the right title to go with this amendment. So thank you all.
Thank you, Representative Talbot Ross. And two of my favorite expressions are one, motion to adjourn. That's not coming up yet, but my next one is we are on our last public hearing of the afternoon. And that is LD 1630, an act to establish a system of proportional fines and to repeal certain fees and assessments. It's LD 1630, and it's presented by our colleague, Representative Pluker. Representative Pluker, welcome to the Judiciary Committee, and please begin your presentation as soon as you feel comfortable.
Thank you, Mr. Chair, and thank you to the entire committee for all your hard work today. Criminal justice is still going what would be next door if we're in the State House. And thank you, because this is a big bill and it's late in the session and it's late in the day, and I appreciate your efforts to hear it. Thank you for the opportunity to present LD 1630, an act to establish a system of proportional fines to repeal certain fees and assessments. The work of this bill is the bread and butter of our criminal justice system. It seeks to find a way to make the burden of a court-assessed fine commensurate to the crime. With our current system of mandatory minimum fines, the fine will necessarily be more punitive on those with less money and less punitive on those with more. This bill creates a system where a crime is assigned an offense unit. The court can use this offense unit in a formula that takes into account the defendant's net income. And in this way, the seriousness of the offense and the person's actual income are incorporated into the assessment of a final fine. The major lift of this bill is the work done by a commission, which will find the relevant statutes in Title 17A that contain the minimum fines, and using the existing minimum fine as a guide, create an offense unit for each of the crimes. The commission is an attempt to at balance with members from the judiciary, the law school, the AG's office, probation services from DOC, public defenders, pretrial services, a public assistance organization, as well as a statewide organization that works to defend our rights, and an expert in criminology. And I just wanted to pause in my written testimony at that point because I've heard back from the Attorney General's office, and they have a couple amendments that they might like to work around with the actual composition of the commission. And I'm very willing to work with the committee and the AG's office on adding prosecutors to that list as you see makes sense. The commission will report back to the Committee of Jurisdiction. Currently in the bill, we thought this was going to go to the Criminal Justice Committee. It's listed as a Criminal Justice and Public Safety Committee. So if you wanted to hear the report back in Judiciary, you would also want to make that amendment in the bill. It's on page 3 of line 37. With legislation, let's see, Committee of Jurisdiction with legislation that could be passed to replace the minimum fines in statute with the suggested offense units. So that report back would be in 2022. And the system of proportional fines would then take effect in January of 2023. One could ask, why is the work of this commission necessary? Couldn't we just remove each of the minimum fines in statute, leaving the assessment up to judicial discretion with a maximum set in statute? This would be the more direct approach if the committee would prefer to leave the actual minimum fines up to the judiciary without legislative input as the seriousness of an individual crime in statute. However, if the committee would prefer to give legislative input, giving the public a voice into how seriously different crimes should be considered, then this system of offense units is an excellent one for providing legislative input and intent to the judges to take into account in their deliberations. Of course, the system will also give an opportunity to the judge to take the defendant's income into account as well. In Chapter 61 of Title 17A, Section 1501, it lays out the purposes behind sentencing provisions. I believe a few of the relevant purposes are appropriate to this conversation. Some of the purposes are to prevent crime, eliminate inequalities in sentences, encourage just individualization of sentences, and to permit sentences based on factors of crime committed. This bill directly advances the work of the state and of that statute in the purposes of sentencing. By clearly setting offense units, we can work to prevent crime. The current system of minimum fines means that the burden of payment of fines falls more heavily on those with less income, so this bill helps to relieve the inequalities of that system. Because the system allows for the income of the individual and the assessment of the fine, the system becomes much more individualized. And the system of offense units allows the judge to permit sentences based on factors of crime committed. We know that the poor are more likely to become involved in our criminal justice system. We also know that the stresses of poverty create the cycles of housing insecurity, employment loss, and drug use that lead to further crime. We must hold people accountable for their crimes while simultaneously reducing the financial stress that could lead them to their next involvement with the criminal justice system. This bill enables our system to be fair and just for the defendant as well as the victims, and it advances the work of our entire criminal justice system, ensuring justice, equity, and demonstrating our fundamental faith in human redemption. And I'm happy to take any questions.
Thank you very much. Whoops.
I was just looking at my notes here, and the other aspect that the Attorney General's office approached me with for a possible amendment is instead of, there is a collection, information collection action or section to this bill. And currently it asks the Attorney General's office to do it, and they recommended shifting that to the judiciary. And I'm very open to that amendment as well.
Thank you very much, Representative Pluker, and thank you for bringing this bill forward to the Judiciary Committee today. I will now turn to questions from the committee, beginning with Representative Moriarty.
Thank you, Mr. Chair. Representative Pluker, do you envision the non-governmental members of the Proportional Fine Commission do you envision that they will serve voluntarily and without pay?
That is how the bill is written, and it would just cover their immediate expenses.
Thank you.
Thank you, Representative Moriarty. Representative Thorne.
Thank you, Mr. Chair. Welcome, Representative Pluker.
Thank you, Representative Thorne.
If I oversimplified this bill, if I make $100,000 a year, I could be fined $1,000 for a crime. If I made $50,000, I could be fined $500 for the same crime.
I would have to look at the formula. So you would what you do
in theory, I'm not looking for exact numbers, just
So I'm not sure that the proportion of income income to fine is correct in your question, but it is true that the fine would be proportional to your income.
Thank you.
Thank you, Representative Thorne. Representative Evangelos.
Thank you, Mr. Chair. Hi, Bill. How's it going?
Very well. Good to see you, Representative Evangelos.
I have a serious question, but the other question is, do you plant anything today?
I haven't today. We've been in criminal justice all day.
All right, buddy. Bill, Representative Pluker, you know that there's like a vicious cycle that develops around people that are caught in poverty, unable to pay their fines, and sometimes it can result in the loss of their driving license.
Certainly.
And then they can't get to work and earn the money to pay the fines. Is this bill going to address those kind of concerns?
That's exactly right. The whole idea is that if the minimum fine on a crime were $500, $500 is worth a whole lot more to someone who's making $500 a week than to someone who's making $1,000 a week. And so if you're in getting involved in the justice system, you have the stress of putting food on the table, stress of getting to work, as you say, that just increases your likelihood of continued involvement with the criminal justice system. And so this gives us an opportunity to make the crime proportional, the fine proportional to the crime, and at the same time get people back out to work and feeding their families as they're able.
And just to follow up on the lines of Representative Thorne's question, have you had the bill examined for constitutionality under the 14th Amendment, the Equal Protection Clause, to make sure that we're not discriminating against folks?
I do not know about that, but I do expect to hear from the AG's office today during the hearing.
That would be a good issue to raise with them. That Representative Thorne's question points to that. Is it constitutional to be fining people different amounts based on their income? That would be a good thing for the work session. Okay.
Great. Thank you.
Thanks a lot. Good to see you.
Thank you, Representative Evangelos. So there are additional questions from committee members for the bill sponsor, Representative Pluker. Representative.
Did you call on me, Representative?
I did.
Thank you very much. Okay, thank you, Mr. Chair. Representative Pluker, welcome to our committee. And again, I wanted to actually ask the same question as Representative Evangelos, but I really wanted to explore where you came up with this idea and if you knew of any models in other states. And if there are not models in other states, I might worry that the 14th Amendment is an obstacle here, but I wanted to put that to you. Thank you.
I did get it. It was model. Yes, thank you. Thank you, Google. It came up quickly. This is model legislation that came from the Brennan Center, and that is where the ideas and the form of the conversation came from for me.
Well, if the Brennan Center proposed it, then they must be confident that it's constitutional. That's interesting. Thank you.
Yes, sir.
Thank you, Representative Babbage. Representative Hagan.
Thank you very much, Mr. Chair. I haven't read yet, but I'm sure it's probably in there. How many of these units would there be?
How many different units?
Yes.
It would be up to the commission to devise the system for it. So they would come up with a system of offense units based upon each crime. So the total number of units, that would be up to the commission to determine.
I did read in rural areas that there would be more need of that. So I guess it's the same question. So I get probably a similar answer. So I'm answering my question with my question. So
okay.
All right. Thank you very much. And I did have I had a couple of questions that were used by Representative Evangelos and Thorne. I won't bother with those, but at that work session, I would be interested in Representative Evangelos stuff. Thank you.
Thank you.
Thank you. Thank you, Representative Hagan. Representative Babbage, do you have another question or is your hand still?
I do not, sir. Thank you.
Thank you very much, Representative Babbage. Are there additional questions for the bill sponsor, Representative Klug or Representative Keim? Senator Keim.
Although I know I would much rather live on a lake than a river. Thank you. Can you hear me okay?
Yes.
Great. Just sort of a question and a comment, I guess. Representative Evangelos just mentioned that this bill would be addressing loss of license, but we just changed the law recently to say that we wouldn't be taking away driver's license for failure to pay fines unless it was a driving infraction. Is that right? Is that something you're aware of, Representative Kluger?
I am not aware of that legislation.
Okay, great. Thank you. Well, yes, we did. We did change that. I think 2 sessions ago. So that part at least. But I think this is a bill well worth exploring. So thank you for bringing it.
Thank you.
Thank you very much, Senator Keim. Are there additional questions for the bill sponsor, Representative Pluker? Seeing none, thank you very much for bringing the bill forward this afternoon, and thank you for taking the time to presenting it to the Judiciary Committee.
Thank you, committee. Thank you, Mr. Chairman.
I will now turn to persons who have registered to testify in support of LD 1630, and I will remind people before we begin that you will be on a 3-minute clock, and that 3-minute clock will be enforced. At 20 seconds left, I'll show you a little yellow Post-it. That's your sign to start wrapping it up, and at 3 minutes, I will let you know that the 3 minutes has expired. And the first witness is, or the first person providing testimony, welcome back to the Judiciary Committee, Mr. Doug Dunbar. As soon as you are comfortable, please begin your testimony.
Thank you, Representative Harnett. I won't call you Senator repeatedly this time, as I did last time, but thank you all for the chance to speak, and thank you, Representative Pluker, for this putting forward this bill. I usually hate the idea, having worked in government for 30 years, of creating a commission. I've been on commissions. I've written reports for commissions that are still sitting on shelves with an inch of dust somewhere. But this is so important. As some of you know, as I said, I spent 30 years in government. I was Maine's Chief Deputy Secretary of State, worked in the governor's office, Congress, blah, blah, blah. None of that matters. What matters is I went to jail for 4.5 months, and it changed my outlook on so many issues. I came to realize there is no such thing in this country as equal justice under the law. It's just a very nice myth. It's something we all learned in grammar school or high school. It doesn't exist. If you're poor and ill, one thing happens to you in our criminal legal system. If you're healthy and wealthy, it's a totally different system. There is no such thing as equal justice under the law. When I went to jail, I realized we heap punishment upon punishment upon punishment exponentially upon the poor. This is what happens. You may know this, but I'm passionate about it because I lived it. So please hear me. If you go to jail and you're poor and your bail is set, it might be $500, it might be $1,000, something that we all could cover. If you're poor, it might as well be $1 million. And you sit there in jail, and this is what happens. Did you have a job? It's gone. Did you have an apartment? It's gone. Did you have main care? It's gone. Not because you've been convicted of anything, but because you're in jail. Did you have children? Perhaps taken. And while you sit there, you want to work on your criminal defense. So you call your attorney's office, as any of us would do. And of course, when you're home, having bailed out of jail, you call your attorney's office and you get a very nice person that connects with your attorney. If you're in jail, that doesn't happen. Most attorneys don't take your call. And so your life unravels. You're not able to properly work on your defense. And then you get out and you're asked to pay a fine that, again, might as well be $1 million for so many people. You've lost your job. You've lost your home. And I have very, very little time left. So all I want to say again is we need to look at issues like this. We exponentially, disproportionately punish the poor. We punish the poor. And what happens? They rotate, cycle in and out of jail, in and out of jail, in and out of jail. The last thing I'll say is, we don't solve problems in this country and in this state. We really don't. We invest on housing people we view as problems. We need to refocus and reform our thinking. We need to solve problems, not just house people we view as problems. Thank you, Representative Harnett.
Thank you. And you're lucky I was muted because I was trying to quiet you for the last 20 seconds. Sorry. Are there questions for Mr. Dunbar from members of the committee? Seeing none, again, thank you very much for taking the time to present your testimony to us today. We greatly appreciate it.
Thank you all. Thank you.
And the next person that I have registered to testify is Larry Danziger. Mr. Danziger, as soon as you are comfortable, unmute your microphone, activate your camera, and I will start my 3-minute clock as you begin your testimony.
Okay, thank you. My name is Larry Danziger. I live in Bangor. Welcome, members of the Judiciary Committee. I hope people will look at the testimony I submitted in writing because what I'm going to talk about is mentioned there. And I want to focus on 3 things. One is answering the question about the 14th Amendment. There were 2 communities in the US that did apparently attempt to do the sliding scale kind of fines, Milwaukee, Wisconsin, and Staten Island. And there's a reference to that somewhere in an article. I could provide that for you if you're interested. Second is I hope people will kind of rethink the idea of every cost needs to be the same for every person. That clearly that doesn't happen with taxation. And Doug Dunbar certainly talked in detail about how it impacts people very differently depending upon their income as well. So instead of thinking everybody should be fined the same amount, fines do impact people differently, and it's very expensive for the state to be fining people a lot of money who can't pay that amount of money. So I hope people will kind of rethink the idea of everything should be the same cost for every person. And the third item is the makeup of the committee. As with a lot of committees, those who are most impacted are not included in committees that influence their circumstances. So my point is to encourage at least 1 and preferably 2 people who actually have not been able to pay fines as part of that committee. If you haven't experienced a problem, you don't really understand it in the same way. Having people on a committee that have actually experienced not being able to pay a fine will really impact how a committee sets those fine amounts. So I hope that will be something that can be included. I've suggested combining a couple of the other individual slots in that 9-person committee to include preferably 2 people who themselves have not been able to pay fines or had difficulty paying them. Thanks.
Thank you very much, Mr. Danziger. We appreciate your coming to the committee today and providing your testimony, and we will review the written testimony that you submitted as well. Are there questions from committee members for Mr. Danziger? Seeing none, again, thank you very much for your time. Greatly appreciate you being here today. The next person that I have registered to testify is Peter Lehman, but ask for, he's already been moved over. Mr. Lehman, welcome back to the Judiciary Committee. As soon as you are comfortable, please begin your testimony, and I will begin the 3-minute timer.
Thank you, Representative Harnett, Senator Carney, distinguished members of the committee. My name is Peter Lehman. I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition, whose goal is to promote restorative practices in order to increase public safety and the health of our community. Anatole France once wrote, "The law, in its majestic equality, forbids rich and poor alike to sleep under the bridges of the Seine, to beg in the streets, and to steal their bread." A law that treats everyone equally might also set an equal penalty for sleeping under that bridge. Rich or poor all pay the same fine for the same dubious privilege. Doesn't seem fair. It seems that the same fine would have very different impact. If the poor person sleeping under the bridge had money to pay the fine, they wouldn't have had to sleep there. For a fine to be equal, I'm learning to talk. For a fine to be equal, it should be equal burden. It should have the same impact. That way it can serve as an equal deterrent, as the same lesson or message that we talk about sending. So same is not really the same as equal. As I understand it, this bill calls for proportionate fines that are roughly equal in their impact, in their burden, so that very different people will be equally burdened. Of course, this simple example assumes that fines will be the same, and in fact, that's not true in Maine. Fines for the same offenses are often wildly different and often not proportionate to the seriousness of the offense. That's what this bill is designed to fix. In addition, my work with the Maine Prisoner Reentry Network, I see a long-term impact of large fines imposed on people with very few means to pay them. These fines hang over their heads for years and even decades, sabotaging their efforts to change. I may be naive, but it seems to me that the major purpose of fines is to encourage people to change, not put another barrier in their way to change. We believe that the bill helps to remedy that. We think it's a step towards justice and a good idea. I urge you to vote ought to pass. Thanks for your attention and support, and I'll be happy to answer any questions you have.
Thank you very much, Mr. Lehman. The committee appreciates you taking the time to provide your testimony today and for submitting it in writing as well. Are there questions from committee members for Mr. Lehman? Seeing none, again, thank you very much for taking the time.
It's good to see you all. Thank you very much.
Okay. And I believe that I have no one left on my list who I see in the attendee room who was registered to testify in favor of LD 1630, but I will check one more time and ask if there's anyone in the attendee room who wishes to speak in favor of LD 1630. Please raise your electronic hand. And seeing no one, I will move to ask if there is anybody in the attendee room who wishes to speak in opposition to LD 1630 to please raise your electronic hand. And seeing none, I will now turn to persons who have registered to testify neither for nor against LD 1613 to please raise your electronic hand. And I would ask committee clerk to move over Francine Stark, followed by Julie Finn. And Ms. Stark, welcome back to the Judiciary Committee. As soon as you feel comfortable, please begin your testimony, and I will begin the 3-minute clock. Nice to see you again.
Thank you very much. I did not prepare written comments this afternoon, but thank you very much, chairs and committee members. On behalf of the Maine Coalition to End Domestic Violence, I wanted to just make 3 points. First of all, I commend Representative Pluker on the ideas behind this bill. It seems very important for issues of equity. And so very much support the intentions. The only consideration we have is that it may be that certain fees and assessments affected by the work of the commission might have an impact on the Victim Compensation Fund. The Victim Compensation Fund is funded by certain fees and assessments on people who have committed crimes. That in and of itself is an important public policy question that deserves really deep examination to tie those two things together, but they are tied. And so as this commission is comprised of various folks, it's important to have people on it who will be able to take into account any impact that this may have on the Victims' Compensation Fund and attend to that impact. It's not a reason to not do what this bill sets out to do, but we need to make sure that we attend to the health and longstanding importance of the Victim Compensation Fund that addresses important harms from crimes against persons. I believe this is it is administered out of the Attorney General's office, and so representatives from the AG's office would certainly be important about that, and anything else we can offer from victim service perspective in the work session or otherwise, we're happy to provide.
Thank you very much, Ms. Stark, for presenting your testimony to the committee today. Are there any questions from committee members for Ms. Stark? And seeing none, again, thank you very much for your testimony.
Thank you all.
And we now turn to our last person registered to testify, Ms. Julie Finn. And Ms. Finn, I feel sorry because usually you're right before lunch, and now you're right before the end of the day. I don't take this personally. It's just how the schedule seemed to turn out today. So as soon as you are comfortable, please begin your testimony. And thank you for being here.
Yes, whether morning or afternoon, it seems I'm always last. Representative Harnett, Senator Carney, members of the Joint Standing Committee on Judiciary. My name is Julie Finn. I represent the judicial branch and I reside in Portland. I would like to provide some comments about this bill. The judicial branch does not oppose the establishment of a proportional fine commission to conduct a comprehensive review of all criminal and civil fines and propose needed changes to ensure consistency. Like other aspects of the criminal code, an extensive study of the fine structure has not been completed recently. As we have stated in previous testimony, a complete overhaul of the main criminal code has not been done since 1976 and could be considered in the context of this bill and other bills proposed this session. The judicial branch does not support the provision of the bill in proposed Title 17A, Section 1784, which establishes a computational proportional fine process. This section requires the court first to require a defendant to file a statement of net income and deductions as provided in rules adopted by the court. The court rules would presumably track and incorporate the methodologies established in the definitional section 1702. Given the complexity of the computation of net income, including factoring the deductions mandated in the statute, it is clear that some defendants may be up to the task while others will not. The court is given limited authority to depart from the self-reported income of a defendant. The court is allowed to deviate from the self-reported amount, but only upon clear and convincing evidence that a defendant earned income of a different amount. And in a large number of cases, an indigency determination has already been completed to establish a right to assigned counsel. Having a judge or judicial staff perform a second indigency determination seems duplicative and perhaps inefficient. In 2019, for example, there were 6,089 fines imposed in Title 17A cases. That's the criminal code. When the number of fines is considered together with the complexity of the calculation, the burden on the courts seems significant in this bill. Thank you very much for your consideration, and I'll try to answer any questions if you have any at this late hour.
Thank you very much, Ms. Finn. Thank you for providing testimony to the committee this afternoon. Are there questions from committee members for Ms. Finn?
Thank you.
That is the end of, you're very welcome. That is the end of my lists, but I will check the attendee room one more time to see if there are any persons wishing to be heard, neither for nor against LD 1630. If so, please raise your electronic hand. Seeing none, having heard testimony from all those persons present wishing to provide testimony to the Judiciary Committee, I now close the public hearing on 1630, which brings the committee's work today to an end until I ask the question of our wonderful analyst if she has anything that she needs to share with us before we adjourn for the day.
I do not. I was hoping I'd have amendments ready for you to review tomorrow, but I try to get them to you 24 hours in advance and I haven't done that. So no amendment review tomorrow.
Now, does that have anything to do with us keeping you in hearing all day and all night?
Who knows?
Okay.
We're all in it together, right?
Thank you, Peggy. Representative Thorne?
Thank you, Mr. Chair. I just wanted to make a comment that I thought it was cute that Miss Finn thought 4:30 was late. Usually we're just getting started.
You know, I felt like we were just warming up and getting into our groove, but I'm not unhappy that I will now ask if there's anybody who would like to make a motion to adjourn, and we will see each other tomorrow at 9 o'clock. Motion by Representative Thorne, seconded by Representative Babich. Passes unanimously. Thanks everybody for all of your hard work today. Greatly appreciate the effort of everyone involved. Take care.
Okay. Good
See
night.
you tomorrow.
Night.
See you all.